Winslow, secretary. So you get the LEP off the way first. So because I know it's LEP, and so it's easier. Easier. I'll just look for the last one. Everything over there.
Hi, question, Commissioner. I'm just curious, that number 6 is, what's the house called? But he's not a house call. Did you want me to move him up? No. Yeah, maybe. It's okay. Okay. Got it. Thank you. Bye.
Normally they'll come to the state right here, so I use normally. And I'll come over and tell you about it. Once you open that door, I'll tell you about it. I have a mark on it. Yeah, and I have her paper report on it. Start her back. All right.
Good morning. You may be seated. You may be seated.
The interpreter's on.
Good morning. This is the time set for the initial appearance calendar for August 27th, 2025. Is the interpreter present? Is the interpreter able to hear the court?
Judge, this is Miss Sauer. I can hear you if that helps.
Okay, so the reason I was asking is that typically when I start, the interpreter interprets everything that I say. So I'm going to start again. Is it Ms. Allen, the interpreter?
He's on there, Roberto.
Okay, so can we
Sure.
let's put it in the chat and see what's going on. I don't think he's.
Yeah, I don't think
So can we, if he doesn't respond, do we need to remove him and maybe he'll call back in? Mr. Wilson, are you able to hear the court? Are we able to just email him? Can we ask him to maybe turn up the volume on his side, because everybody else can hear us, so it must be him.
Remember the number outside. So I'm on. Yeah. Because it's on the paper. It's got for all the counts. So box. I'll just draw a line all over the last page. Basically.
He's talking, it's his equipment.
Yeah.
Yes.
And I'm guessing that it must be his headset.
Mm-hmm.
That's very done. Right there. That's how I know who's always next. Just look out here, this is danger, and this is what's going. Yeah, a couple of fixed charges. So,
Good morning.
Yes, we can hear you now.
Perfect, thank you.
All right. So, good morning, everyone. This is the time set for the 8 a.m. initial appearance calendar for August 27th, 2025.
Buenos días, este es el calendario de comparecencia inicial del día 27 de agosto de 2025 de las 8 de la mañana.
The court's orders for the taking of fingerprints and DNA samples made on the 1st of this month will apply to all matters on this calendar.
Las órdenes hechas por la oficina del comisario en la audiencia del primer día del mes de que a todos los acusados se les tomen las muestras de ADN y huellas digitales se va a aplicar a todos los casos del calendario del día de hoy.
I am Commissioner Dyer, and there are a few things that I'd like to explain before we get started.
Soy la comisionada Dyer y hay algunas cosas que quiero explicarles antes de que iniciemos.
First, I'm going to call each of you up to the podium one by one.
Primero que nada, voy a nombrarles uno por su nombre y van a pasar a pararse detrás del podium.
I am going to ask you for your first and last name and your date of birth.
Voy a preguntarles su nombre completo y fecha de nacimiento.
I will then tell you why you are here today.
Después de eso les voy a informar por qué están presentes el día de hoy.
I will also tell you whether or not an attorney has been appointed to represent you.
Después de eso les voy a informar si es que se les ha asignado un abogado a su caso o no.
And then I will tell you what your upcoming court dates will be.
Y luego les voy a decir cuáles van a ser sus próximas audiencias.
Then I will let you know what your bond will be if you are eligible for bond.
Luego les voy a informar si es que tienen alguna fianza.
And lastly, I will advise you of your release conditions.
Y por último les voy a decir cuáles son sus medidas cautelares.
Some of you may have some questions while I'm providing this advisement to you.
Algunos de ustedes tal vez tengan algunas preguntas mientras les doy toda esta información.
I just ask that you do not interrupt me while I'm providing the advisement to you.
Solamente les pido que no me interrumpan mientras les estoy dando toda su información.
Please hold your questions until I complete the advisement.
Por favor, háganme preguntas si es que las tienen hasta que les termine de dar toda su información.
You are also cautioned to keep your questions directed to your release conditions only.
Sin embargo, yo les pido que solamente sean preguntas acerca de sus medidas cautelares.
This is a recorded proceeding, and anything that you say could be used against you.
Ya que esta es una audiencia que está siendo grabada y cualquier cosa que digan en esta audiencia puede ser utilizado en su contra.
Any legal questions surrounding your case should be directed towards your attorney.
Cualquier pregunta de tipo legal que tengan sobre su caso se la tienen que hacer a su abogado.
The first person that I'm going to call to the podium is Mr. Danger.
La primera persona que vamos a llamar para que pase el podio es el señor Danger.
Good morning, sir. Can you please state your first and last name and your date of birth?
Buenos días, señor. ¿Nos puede dar su nombre completo y su fecha de nacimiento?
Daniel Montesino González, 0317 de 1995.
Danger Montesino González, March 17, 1995.
Sir, you are here today on a new case.
Señor, usted está presente el día de hoy aquí por un nuevo caso.
You have been charged with 14 counts of organized retail theft of merchandise, a class 4 felony.
Usted tiene 14 acusaciones en su contra de robo organizado de tiendas departamentales, lo cual es un delito clase 4.
And 14 counts of shoplifting, removal of goods, a class 5 felony.
Y 14 acusaciones de robo en tienda, sacar mercancía, lo cual es un delito clase 5.
The date of these alleged offenses start on May 10th of this year.
Las fechas en las que supuestamente ocurrieron estos ilícitos empezaron el 10 de mayo de este año
Through May 13th of this year.
hasta el 13 de mayo de este año.
I did find probable cause as to all of the charges.
Determiné que existe motivo fundado de procesamiento para estas acusaciones.
I did appoint an attorney to represent you in this matter.
Le he asignado un abogado para que lo represente en este caso.
You will have a status conference hearing on September 3rd at 8:30.
Va a tener una consulta de actualización el día 3 de septiembre a las 8:30 de la mañana.
You will have a preliminary hearing on September 5th at 8:30.
Y va a tener una audiencia preliminar el día 5 de septiembre a las 8:30 de la mañana.
You have a secured appearance bond in the amount of $50,000.
Tiene usted una fianza con garantía en un monto de $50,000.
If you are able to post bond,
Si usted puede pagar esta fianza,
you cannot return to the scene of any of the alleged crimes.
no puede regresar a ninguno de los sitios de los supuestos ilícitos.
You cannot have any contact with any alleged co-defendant.
No puede tener ningún tipo de contacto con ninguno de los coacusados.
And you cannot possess any weapons.
Y no puede poseer ningún arma.
Failure to comply with your release conditions,
Si usted quebranta alguno de estos términos o condiciones de sus medidas cautelares,
or failing to appear for your court dates,
o si no comparece a sus próximas audiencias,
would result in the loss of any bond that you post,
resultaría en la pérdida de la fianza que haya pagado.
a warrant would be issued for your arrest,
Se liberaría una orden para su arresto
an additional bond could be imposed.
y se le pondrían imponer otras fianzas.
This takes care of everything that I have to tell you about this morning.
Eso es todo lo que tengo que informarle el día de hoy.
If you have no questions for me,
Si no tiene ninguna pregunta para mí,
please step to your left,
por favor pase a su izquierda
and the officer will give you your paperwork.
y el agente le va a dar todos sus documentos.
Mr. Wilson, before I excuse you, can you inquire as to whether or not anybody else is in need of your services?
Yes, Your Honor. ¿Habrá alguna otra persona que requiera los servicios de intérprete en español?
Anybody else need an interpreter? We're good, Your Honor.
Okay. Mr. Wilson, thank you so much. You may be excused.
Thank you, Your Honor.
Mr. Winslow, will you please come to the podium? And Christina Mills, will you please have a seat in the chair? Sir, can you please state your first and last name and your date of birth?
Robert Winslow, 9/15/70.
You are here today on two matters. You have a warrant that was issued when you failed to appear for your court date, and then you had a direct complaint that was filed. I'm going to first talk to you about the direct complaint that was filed. You were charged with 1 count of possession of dangerous drugs for sale, a Class 2 felony, 1 count of possession of narcotic drugs for sale, a Class 2 felony, 1 count of possession of dangerous drugs for use, a Class 4 felony, 1 count of narcotic drugs for use, a Class 4 felony, 1 count of possession of a weapon during a drug offense, a Class 4 felony,
What?
and 2 counts of possession of drug paraphernalia, a Class 6 felony. The date of these alleged offenses is August 6th of 2024. I did appoint an attorney to represent you. You have a status conference hearing on September 3rd at 8:30 and a preliminary hearing on September 5th at 8:30.
Okay.
Because you were on felony release at the time that these alleged offenses occurred, you're not eligible for bond today. So I did have to schedule an evidentiary hearing for you for September 3rd at 1:30.
Okay.
Then as to your warrant for failing to appear for a court date, an attorney was already appointed to represent you in this matter. You have a status conference hearing on September 3rd at 8:30 and a preliminary hearing on September 5th at 8:30. That warrant had a secured appearance bond in the amount of $500. I would caution you against attempting to post bond. It will not secure your release. You should wait until after your evidentiary hearing on the 5th to see whether or not bond will be granted.
Okay.
This takes care of everything that I needed to advise you of this morning. If you have no questions for me, if you'll step to your left, the officer will give you your paperwork.
Well, I don't know if it makes any difference now, but there was no, I had no weapon that was mine.
So that's something that you will talk to about to your attorney.
Okay.
This is something that a direct complaint was filed.
Okay.
And so the judge that signed off on it found probable cause on that. So I did not see the information. I don't know.
Okay.
But either way, you were on felony release. And so there are other charges that were indicated in that direct complaint. So you would still not be bondable. Okay?
All right.
All right. Thank you. I'm so sorry. Enrique Siqueiros, if you'll please come to the podium, and then Ms. Mills will come. I'm so sorry. Ms. Mills, if you will please have a seat. Thank you. Sir, can you please state your first and last name and your date of birth?
Enrique Siqueiros, 7/29/82.
You are here today on a new case. You were charged with 1 count of possession of narcotic drugs for sale, a Class 2 felony, and 1 count of possession of a weapon during a drug offense, a Class 4 felony. The date of these alleged offenses is August 14th of 2025. I did find probable cause as to both counts. I did appoint an attorney to represent you. You have a status conference hearing on September 3rd at 8:30 and a preliminary hearing on September 5th at 8:30. You have a cash-only appearance bond in the amount of $100,000. If you are able to post bond, you cannot possess any weapons. Failure to comply with your release conditions or failing to appear for your court date would result in the loss of any bond that you post. A warrant would issue for your arrest and additional bond could be imposed. This takes care of everything that I needed to advise you of today. If you have no questions for me, you'll step to your left, the officer will give you your paperwork. Thank you.
Thank you.
Right here.
Ms. Mills, will you please come to the podium? And Mr. Stewart, if you will please have a seat in the chair. That's Davon Stewart. Good morning, ma'am. Can you please state your first and last name and your date of birth for me?
Christina Francisco, January 13, 1978.
You are here today because a direct complaint was filed where you were charged with 1 count of fraudulent schemes or artifices, a Class 2 felony, 1 count of theft or control of property, a Class 3 felony, and 1 count of forgery with a written instrument, a Class 4 felony. The date of these alleged offenses is July 1st of 2020. I did appoint an attorney to represent you in this matter. You have a status conference hearing on September 3rd at 8:30 and a preliminary hearing on September 5th at 8:30. That direct complaint had a secured appearance bond in the amount of $10,000. If you are able to post bond, you cannot return to the scene of the alleged crime. Failure to comply with your release conditions or failing to appear for your court date would result in the loss of any bond that you post. Another warrant would issue for your arrest. An additional bond would be imposed. This takes care of everything that I needed to advise you of this morning. If you have no questions for me, if you will please step to your left, the officer will give you your paperwork.
This is the first that I've ever heard about it.
This warrant was issued on August 1st of 2022.
I don't know nothing about it.
I'm not sure if you moved from the time when you were arrested initially on these offenses. Typically, this is what happens. Let me see. Yeah, a direct complaint was filed. It was mailed to you on July 6th of 2022. It was returned on July 25th of 2022, and then this warrant was issued. But in addition, because this is a direct complaint, I don't receive the information. I don't review the information. The judge who reviewed the information back in July of 2022, based on the information that was reviewed and considered, that's the bond that they ordered. And so I'm just here to tell you how much that is, what the bond is. That's what's on the order in the warrant. You have any other questions? Okay, if you'll step to your left, the officer will give you your paperwork. Thank you.
There you go.
Mr. Stewart, will you please come to the podium? And Eric Thomas, will you please have a seat in the chair? Sir, can you please tell me your first and last name and your date of birth?
Devon Stewart, 1792.
You are here today because you have one new case, and then you have a probation violation warrant. On your new case, you were charged with 1 count of possession of a dangerous drug, a Class 4 felony, 1 count of resisting arrest with physical force, a Class 6 felony, and 1 count of criminal trespass, a Class 1 misdemeanor. I did find probable cause as to all of those charges, and I did appoint an attorney to represent you. You have a status conference hearing on September 3rd at 8:30 and a preliminary hearing on September 5th at 8:30. You have a secured appearance bond in the amount of $2,500. And then as to your probation violation warrant, I did appoint an attorney to represent you in that matter. You have a probation revocation possible disposition hearing on September 3rd at 8:30. That warrant had a secured appearance bond in the amount of $5,000. So between your 2 cases, you have a total secured appearance bond of $7,500. If you're able to post bond, oh, and I'm so sorry, on your probation revocation or your probation, you do have a revocation hearing, possible disposition hearing on September 3rd at 8:30. If you're able to post bond, you must appear for all of your court dates. You have the following release conditions. You cannot return to the scene of the alleged crime. You cannot possess any weapons. And you must contact probation within 72 hours of your release. Failure to comply with release conditions or failing to appear for your court date would result in the loss of any bond that you post. A warrant would issue for your arrest and additional bond could be imposed. So this takes care of everything that I have to tell you about this morning. If you have no questions for me, if you will please step to your left, the officer will give you your paperwork. Thank you. Mr. Thomas, will you please come to the podium? And Ms. Kelly, if you will please have a seat in the chair. Good morning, sir. Can you please state your first and last name and your date of birth?
Yes, Eric Thomas, 62690.
You are here today because you have a warrant out of Casa Grande Justice Court. I did appoint an attorney to represent you in this matter. You will have an arraignment hearing on September 2nd at 8:30. Your warrant had a cash-only bond in the amount of $1,865.18. If you are able to post bond, you must appear for your court date. If you fail to appear for your court date, that would result in the loss of any bond that you post. Another warrant would issue for your arrest and additional bond could be imposed. This takes care of everything that I have to advise you about this morning. If you have no questions for me, if you will please step to your left, the officer will give you your paperwork. Thank you.
Thank you.
Ms. Kelly, will you please come to the podium? Good morning, ma'am. Can you please state your first and last name and your date of birth?
Marie Kelly, 2195.
You are here today because you have a probation violation warrant. I did appoint an attorney to represent you in this matter. You will have a probation revocation possible disposition hearing on September 3rd at 8:30. Your warrant had a secured appearance bond in the amount of $1,000. If you are able to post bond, you must appear for your court date. If you fail to appear for your court date, that would result in the loss of any bond that you post. Another warrant would issue for your arrest, and additional bond could be imposed. This takes care of everything that I have to advise you of. Step to your left, officer will give you your paperwork. Miss Osha Marie Williams and Mr. Taiwan Howard, if you'll please have a seat in the chair. Good morning, ma'am. Can you please state your first, last name, and your date of birth?
Oshima Williams, 4695.
You are here today because you have a probation violation warrant. I did appoint an attorney to represent you in this matter. You will have a probation revocation possible disposition hearing on September 3rd at 8:30. Your warrant had a secured appearance bond in the amount of $100. If you are able to post bond, you must appear for your court date. If you fail to appear for your court date, that would result in the loss of any bond that you post. Another warrant would issue for your arrest, and additional bond would be imposed. This takes care of everything that I needed to tell you this morning. If you have no questions for me, if you'll step to your left, officer will give you your paperwork. Thank you.
Right here.
Mr. Howard, will you please come to the podium? And Mark Colley, if you'll please have a seat in the chair.
No, to the podium.
So, sir, can you
Yeah,
please state your first and last name and your date of birth?
Taiwan Howard, 82182.
You are here today because you have a warrant out of North Mesa Justice Court. Your warrant was for failing to appear for a court date. The charge on that warrant was that you were driving with a license that was suspended, revoked, or canceled. I did appoint an attorney to represent you in this matter. You have an arraignment hearing on September 2nd at 1 p.m. You have a secured appearance bond in the amount of $250. If you are able to post bond, you must appear for your court date. And I'm going to emphasize that you are not to be driving a motor vehicle without a driver's license. A failure to comply with your release conditions or failing to appear for your court date would result in another warrant issuing for your arrest. I will also let you know that the recommended bond for you in the warrant was $500. I cut it in half
Appreciate that.
to $250. Give you a break, but you need to show up to court, and you should not be driving without a license. You're going to keep in this vicious circle.
Yes.
Okay?
Okay.
All right, that's it. If you have no questions for me, if you'll step to your left, officer will give you your paperwork.
All right, thank you.
There you go.
Mr. Colley, will you please come to the podium? And William Stites, if you'll please have a seat in the chair. Sir, can you please state your first and last name and your date of birth?
Mark Coley, January 18th, 1995.
You are here today because you have one new case and two probation violation warrants. On your new case, you were charged with 1 count of possession of a dangerous drug, a Class 4 felony, and 1 count of possession of drug paraphernalia, a Class 6 felony. I did find probable cause as to both charges, and I did appoint an attorney to represent you. You have a status conference hearing on September 3rd at 8:30 and a preliminary hearing on September 5th at 8:30. You have a secured appearance bond in the amount of $500. As to your 2 probation violation warrants, I appointed an attorney to represent you in those matters as well. You'll have a probation revocation possible disposition hearing on September 3rd at 8:30. Each of those warrants has a secured appearance bond in the amount of $250. So between your 3 cases, you have a total secured appearance bond of $1,000. If you are able to post bond, you must comply with your release conditions, which include that you cannot return to the scene of the alleged crime and you cannot possess any weapons. Failure to comply with those release conditions or failing to appear for your court dates would result in warrants issuing for your arrest, and additional bond could be imposed. This takes care of everything that I have to advise you of this morning. If you have no questions for me, if you will step to your left, officer will give you your paperwork.
I thought I didn't have no more probation.
Well, the reason why you had triggered an automatic probation violation, term 1 violation, when you got arrested on the new charges.
But as for my old probation, that one's canceled, right?
You have cases from 2023 and 2024. Those cases are open. They were not. You were still on active probation on those.
Because I just got released not too long ago, and the release conditions was I do 4 months.
No, you didn't. You were reinstated on probation on May 8th of this year, and you were reinstated for a period of 2 years on one of them. On your other probation, at that same one, your 2 cases that you have, you were reinstated on probation on May 8th of this year, and again, your probation was for 2 years, so you were still on active probation.
But my recent jail term.
Sir, I'm looking at the paperwork from that placed you on probation. I'm looking at it, and it was filed in on May 25th. It doesn't say that your probation was terminated. You were reinstated. That you were continued on probation.
Are you able to see my recent jail term?
This has nothing to do with your jail term. You were in jail, and once you were released, you had a probation. You have probation following your release.
They didn't tell me that. They just released me.
Sir, they would not have just released you. You would have had to sign off on your probation paperwork.
Because they gave me 4 months, but they released me the next day. It's why I don't understand why I'm still on probation.
So the only probation cases that you have are the 2 cases that I talked to you about. I'm not going to continue. I feel like the thing that I say to you, because I'm not telling you what you want to hear. I can't tell you what you want to hear. I can only tell you what is in the court docket. That's what I'm telling you. So if you have a disagreement with that or you think it's not right, you will meet with your attorney, and your attorney can address that with you or further explain things to you.
There you go.
Mr. States, will you please come to the podium? And Mr. Lake, will you please have a seat in the chair? Good morning. Can you please state your first and last name and your date of birth?
William Sykes, 10/22/1996.
You are here because you have 1 new case. You have 2 probation violation warrants, and then you have a warrant out of Surprise Municipal Court. When I first talked to you about your new case, you were charged with 1 count of possession of a dangerous drug, a Class 4 felony, 1 count of resisting arrest, passive resistance, a Class 1 misdemeanor, 1 count of disorderly conduct, a Class 1 misdemeanor, and 1 count of criminal trespass, a Class 2 misdemeanor. I did find probable cause as to all of these charges, and I did appoint an attorney to represent you. You have a status conference hearing on September 3rd at 8:30, a preliminary hearing on September 5th at 8:30. You have a secured appearance bond in the amount of $500. As to your 2 probation violation matters, I appointed an attorney to represent you in both of those matters as well. You have a probation revocation possible disposition hearing on September 3rd at 8:30. Each of those warrants has a secured appearance bond in the amount of $250. And then for your warrant out of Surprise Municipal Court, I appointed an attorney to represent you in that matter. You have an arraignment hearing on September 3rd at 1:30, and that warrant had a secured appearance bond in the amount of $50. So between your 3 cases, or 4 cases, you have a total secured appearance bond of $1,050. If you are able to post bond, you cannot return to the scene of the alleged crime. You cannot possess any weapons, and you must contact your probation officer within 72 hours of your release. Failure to comply with your release conditions or failing to appear for your court date would result in the loss of any bond that you post. Warrants would issue for your arrest again, and additional bond could be imposed. So this takes care of everything that I needed to advise you this morning. If you have no questions for me, if you'll please step to your left, the officer will give you your paperwork.
What is the no disposition?
Pardon me?
The no disposition was I mean.
So I said possible disposition. So when you go for your probation matter, you could potentially resolve your probation case. You'll be heard, and it could potentially be resolved on that day.
Okay. And then you said, so it's a total of $1,500?
No, $1,050.
Okay, so, but it's,
it's secured appearance. So that's, I think it's like $105 plus collateral.
Plus collateral?
Mm-hmm.
Without collateral.
So that I can't help you with. I know that back in holding, they have information for bonding agencies that you can contact and talk to them about if they will be willing to put up bond for you.
Sure.
Okay?
All right. Thank you.
Mm-hmm.
Here's your paperwork.
Mr. Lake, will you please come to the podium? And Nicholas Gutierrez, if you'll please have a seat in the chair. Good morning, sir. Can you please state your first and last name and your date of birth?
Stephen Lake, 9/30/70.
Sir, you were here today because you have a probation violation warrant and then you have a child support warrant. On your probation warrant, I did appoint an attorney to represent you in that matter. You have a probation revocation possible disposition hearing on September 3rd at 8:30. That warrant had a secured appearance bond in the amount of $100. As to your probation, as to your child support warrant, You have a return hearing on September 2nd at 10 a.m., and you have a purge amount for release of $250. And just for the purpose of clarity, you have to pay the full $250 in order to secure your release on the child support warrant. If you're not able to do so, you'll be seen by that judge on September 2nd at 10 a.m. As to your probation secured appearance bond, if you are able to secure your release on both matters, you do need to make sure that you appear for your court date. If you fail to appear for your court date, that would result in the loss of any bond that you post. Another warrant would issue for your arrest, and additional bond could be imposed. So this takes care of everything that I needed to advise you of this morning. If you have no questions for me, if you'll please step to your left, the officer will give you your paperwork. Thank you.
Here you go.
Mr. Gutierrez, will you please come to the podium, and Ms. Gladding, if you'll please have a seat in the chair. Hello, sir. Can you please say your first and last name and your date of birth?
Oh, Your Honor, I'm Nicholas Gutierrez, September 6th, 1984.
You are here today on a new case. You were charged with one count of attempted theft of means of transportation, a Class 3 felony. I did find probable cause, and I did appoint an attorney to represent you. You will have a status conference hearing on September 11th at 8:30, and you'll have a preliminary hearing on September 15th at 8:30. I am inclined to release you to pretrial services. You do have to promise to appear for your court dates. Do you promise to appear for your court dates?
Yes.
You have the following release conditions. You cannot have any contact with the alleged victim. You should not be driving without a valid driver's license. If you fail to comply with your release conditions or you fail to appear for your court dates, a warrant will issue for your arrest and a bond would be imposed. Do you understand?
Yes, Your Honor.
This takes care of everything that I needed to tell you this morning. If you have no questions for me, if you'll step to your left, the officer will give you your paperwork.
Does that entail that I will be able to be released upon my own recognizance?
You're not being released on your own recognizance. You're being released to pretrial services.
Gotcha.
That means you're going to be supervised in the community. So you're not going to be held, but you'll be released to pretrial services who will supervise your release in the community.
Okay, I just wanted to understand. Thank you.
Mm-hmm. So if you'll step to your left, the officer will give you your paperwork. Thank you. Ms. Gladdy, will you please come to the podium and...
Hi. Patricia Gladding.
Hold on 1 second.
Oh, I'm sorry.
Marissa, on number 18 and I think, let me make sure. Oh, no, they're not. Okay, sorry. I apologize for that delay.
10/23/93.
Thank you. You are here today on a new case. You were charged with one count of possession of a dangerous drug, a Class 4 felony, and one count of possession of drug paraphernalia, a Class 6 felony. I did not find probable cause as to the possession of the dangerous drug. I did find probable cause as to possession of drug paraphernalia. I did appoint an attorney to represent you in this matter. You do have a status conference hearing on September 11th at 8:30 and a preliminary hearing on September 15th at 8:30. I am inclined to release you to pretrial services. You do have to promise to appear for your court dates. Do you promise to appear?
Absolutely.
You have the following...
I have 2 small children. I will be there.
Hold on. You have the following release conditions. You cannot return to the scene of the alleged crime, and you cannot possess any weapons. Failing to appear for your court dates or failing to comply with your release conditions will result in a warrant issuing for your arrest, and a bond will be imposed. So what I want to be clear, since you wanted to tell me that you have children at home,
yeah.
If you don't show up to your court date...
You won't. I won't.
Let me finish. If you don't show up to your court date, a warrant will issue, and there'll be a bond, and you will not be released without that bond. So please understand, you need to show up for your court date.
Oh, I will.
Okay, so
Absolutely.
this takes care of everything that I needed to advise you of today. If you have no other questions for me, I'm not sure, did he give you your paperwork?
My only question, will they reach out to me or I have to go
Your
to them?
paperwork will have all the information regarding pretrial services, how you contact them. Also, before you leave, they will give you additional information about what is expected of you while you're on
Okay.
supervised release.
Okay.
Okay?
All right.
All right. So I believe your paperwork is right there.
Yeah, thank you very much.
Anna Samaningo, if you'll please come to the podium, and Stanton Williams, will you please have a seat in the chair? Good morning. Can you please state your first and last name and your date of birth?
Ana Urias Samaniego, November 19, 2005.
You were here today because you were charged with 1 count of assault with intent to injure, a class 1 misdemeanor. I did find probable cause as to that offense. Due to the nature of the charge, you're not entitled to a court-appointed attorney. You have an arraignment hearing on September 16th at 8:30. I am inclined to release you on your own recognizance today. You do have to promise to appear for your court date. Do you promise to appear?
Yes, I do.
You have the following release conditions. You cannot return to the scene of the alleged crime. You cannot initiate any contact with the alleged victim, and you cannot possess any weapons. If there is an order of protection or an order against harassment that is issued, you must comply with that. You cannot live at the same location as the alleged victim. You are permitted 1 civil standby with local law enforcement to assist you in collecting your essential belongings. If you violate the no victim contact order in this case, you could be charged with aggravated harassment, which is a class 6 felony. Failure to comply with your release conditions or failing to appear for your court date would result in a warrant issuing for your arrest, and a bond will be imposed. This takes care of everything that I needed to advise you of this morning. If you have no questions for me, you'll step to your left. Officer will give you paperwork.
So, will I just be like released?
I'm releasing you today, but you have all the release conditions that I just told you, so you cannot go back home.
I was advised to tell you that I don't have a place to really like go to.
Well, that's not my concern. My concern is who the alleged victim was that lives in the home. The alleged victim was your mom. And so you can't, amongst your family, hopefully somebody can find some place for you to live. But right now, I am concerned about the safety of your mom. Okay? All right, if you'll step to your left, the officer will give you your paperwork. Come on in, Stanton. Hi, Stanton.
Hi,
Can you tell me your first and last name?
Stanton Williams, 1807.
So before we get started, I just want to say that I was really sad to see your name. And I know you remember our conversation that we had before I came over here, right?
Mm-hmm.
That I would hope that things got better so that I would not see you over here.
Yeah.
So I'm pretty sure you were probably feeling some type of way to see that it was me. But we're going to go ahead and move forward with it, okay? I just wanted to get that out of the way.
All right.
You are here today on a new case. You were charged with 2 counts of criminal damage, a class 1 misdemeanor. The date of the alleged offenses is August 26th of 2025 and August 19th of 2025. Due to the nature of the offense, you are not entitled to court-appointed counsel. You do have an arraignment hearing on September 23rd at 1:30. I am going to release you on your own recognizance. You do have to promise to appear for your court date. Do you promise to appear? You have the following release conditions. You cannot return to the scene of the alleged crime. You cannot initiate any contact with the alleged victim. And you cannot possess any weapons. If there are any orders of protection or orders against harassment that are issued, you must comply with those orders. You cannot live at the same location as the alleged victim. And you are permitted 1 civil standby with law enforcement. You are also advised that if you violate the no victim contact order in this case, that you could be charged with aggravated harassment, which is a class 6 felony. Failure to comply with your release conditions or failing to appear for your court date would result in a warrant issuing for your arrest, and a bond would be imposed. So if this takes care of everything that I have to tell you, do you have any questions for me?
Oh, Your Honor.
Okay. So are you going to be staying with your mom?
Yeah.
Okay. You step to your left. Officer will give you your paperwork.
Hold on real quick. All right, stop traffic.
Kelly Baker, date of birth May 31st, 1962, is here on a new case. Ms. Baker is not physically present in court due to medical isolation. She was charged with one count of aggravated assault, DV, impeding breathing, a class 4 felony. I did find probable cause as to that offense, and I did appoint an attorney to represent her. She has a status conference hearing on September 3rd at 8:30, a preliminary hearing on September 5th at 8:30. Prior to the hearing starting, I did review a victim impact statement. The court did take into consideration the victim's concerns and wishes. Ms. Baker will have a secured appearance bond in the amount of $25,000. If she's able to post bond, she'll be released to pretrial services on electronic monitoring. She cannot return to the scene of the alleged crime. She cannot initiate any contact with the alleged victim, and she cannot possess any weapons. If there are any orders of protection or orders against harassment that are issued, she must obey the terms of those orders. She cannot reside at the same location as the alleged victim. She will be permitted one civil standby with local law enforcement to assist her in collecting her essential belongings. She will also be cautioned that if she violates the no victim contact order in this case, she could be charged with aggravated harassment, which is a class 6 felony. Ms. Baker will be advised that if she fails to comply with release conditions or she fails to appear for her court date, any bond that she posts will be lost. A warrant would issue for her arrest and additional bond would be imposed. I will meet with Ms. Baker. If any changes are needed, I will do so either on the record or in writing. Danny Villegas, will you please come to the podium? Ms. Sauer, do you want to state your appearance?
Yes, Your Honor. Dawn Sauer on behalf of.
And Mr. Cummings? Mr. Cummings? Okay, Mr. Vegas, your attorney is, I'm not sure if he's not available right now, so I'll have you have a seat. When he's available, I'll call you back in.
Judge, I apologize. Was that Mr. Villegas?
Yes.
I am here. Sorry, I walked away. I'm still in court in Phoenix as well. If he's available now, we can. If not, we can recall him later. Up to you, Judge.
He is here. He is here. Mr. Cummings, can you state your appearance?
And good morning, Your Honor. Ryan Cummings on behalf of Mr. Villegas, who is present in custody.
Thank you. And Mr. Villegas, will you please state your first and last name and your date of birth?
Danny Villegas, 5/17/2005.
Mr. Cummings, did you have an opportunity to review the charges with your client, or do you want me to review them?
Judge, we would waive the formal reading of the charges. I have not had a chance to go over them with my client, but I believe that he knows what those charges are. So we would waive formal reading of those and move on to the bail process.
Well, I first do need to confirm, Mr. Vegas, do you know what you've been charged with? Yes or no? If you don't know, I can tell you.
Not exactly, no. But
okay. And for your information, Mr. Cummings, we have cleared the courtroom.
Okay. Thank you, Judge.
Mr. Cummings, you were charged with 10 counts of sexual exploitation of a minor, a class 2 felony. I did find probable cause. I'm sorry, Mr. Cummings, did you want to be heard on probable cause?
No, Your Honor.
I did find probable cause as to all of those charges. I did make a finding of indigency, just if in the future he is in need of court-appointed counsel. So we will move on to the court dates. You will have a status conference hearing on September 3rd at 8:30, a preliminary hearing on September 5th at 8:30. I know that there is going to be some discussion regarding release conditions, so I will first hear from the state. I did review your recommendations, but I do understand that you would like to make a record.
Yes, Your Honor, thank you. Based on the large quantity of child sexual abuse material that was found on the defendant's phone, and especially given the age of the children in those videos, and the state's concern about the defendant's danger to the community, to minors, the fact that there is a minor child that was living in the defendant's home, the state believes a high cash bond is appropriate and is requesting a $250,000 cash-only bond if posted, electronic monitoring, no contact with any minors at all, and no internet, among other things.
Okay, and Mr. Cummings?
And thank you, Your Honor. Your Honor, I would ask that he be given a $25,000 secured appearance bond. I would note that the pretrial services recommended OR as their final recommendation, at least from what I read that I got this morning. We have no issues with the electronic monitoring. I would also indicate that if he were to be released, obviously electronic monitoring, pretrial services is fine. We'd have no objection to those. We also would have no objection to him having to locate a residence outside of his home that would not be, and provide that to pretrial services that would have no contact with minors, as well as the no internet. I agree that all of those things are appropriate, but Judge, I think, and I think in my notice of appearance, I noted Howard Dwarman was going to be the attorney that's going to be handling this matter moving forward. The reason I'm appearing for his initial appearance is that Mr. Dwarman is in Greece right now, but we've had multiple conversations with Mr. Villegas' parents last night, this morning, 3 a.m. this morning, to secure everything, to make sure that we could appear for Mr. Villegas this morning. So I have no doubt that he would be available to appear. But again, Judge, we're not in opposition to, I think electronic monitoring is required via statute, but also pretrial services. And I believe that he would, is showing that, he's doing everything he needs to do to hire his counsel to be able to appear. Judge, I think a $25,000 secured appearance bond would be sufficient to secure his appearance. And I think with the additional requirement that he not be able to reside back at his home, he has to go somewhere else where there's not a minor in there. I think that can secure enough for the community and any minors that are available. So Judge, that's what I would ask. And again, noting that pretrial services, their final recommendation was OR release, which again, there has to be electronic monitoring on this. So I don't think that's it, but I think a $25,000 secured appearance bond would be sufficient to secure his appearance, Judge.
Well, I will just state for the record that I don't agree with the pretrial services recommendation, and that is sometimes the case where pretrial services, for whatever the formulation is that results in their recommendations, maybe don't take into consideration some other factors or information that is made available to the court. And in this instance, I was very troubled by the probable cause statement, the information that was provided in there. First, just very troubled that just the number of, just the amount of CSAM that is alleged to be in possession of the defendant. Also, the information in the probable cause statement that this has been going on for some time. The age of the children that is involved in these files, and the fact that there is a young child living in the home of the defendant. And while the family has secured an attorney for him, according to the probable cause statement, the defendant has been involved in collecting this material since he was a teenager. So I'm not sure what's going on in the home that would ensure the safety of the minor child that's in the home, and I'm also concerned about minor children in the community. So absolutely, for those reasons, I don't believe that to follow the pretrial recommendations is appropriate here. I do look at the criminal history or lack thereof of the defendant. I have taken that into consideration in making my decision, but I'm also looking at he's been charged with 10 counts, and if he is found, if he's actually charged and found guilty, there's also going to be mandatory prison time here. So I have to weigh all of these things in making a determination of what I believe is the appropriate release conditions as well as bond. I believe that a cash bond in the amount of $100,000 is appropriate here. That if he's able to post bond, that he will be released to pretrial services on electronic monitoring. That he cannot have any contact with any minors. That he cannot have any access to any electronic means except for school and work. Mr. Vegas, if you are able to post bond, you must comply with all of these release conditions and you must appear for your court dates. If you fail to do so, that would result in the loss of any bond that is posted. A warrant would issue for your arrest and additional bond would be imposed. Mr. Cummings, was there anything more that you wanted to be heard on at this time?
No, Judge, not at this time. Thank you.
Ms. Sauer?
Nothing else. Thank you, Your Honor.
Mr. Cummings, we will email you a copy of the release conditions.
Thank you, Judge.
Okay, that concludes this matter. Mr. Cummings, you may be excused. And Mr. Aveas, if you'll please have a seat. Ms. Williams, will you please come to the podium? And Mr. Williams, if you'll please have a seat in the chair. Can you please state your first and last name and your date of birth?
Renisha Williams, 8189.
You are here today on a new case. You were charged with 1 count of child sex trafficking, a Class 2 felony. The date of the alleged offense is August 10th, 2025. I did find probable cause as to that charge. I did appoint an attorney to represent you. You have a status conference hearing on September 3rd. Oh, I'm so sorry, Ms. Sowers. Were you wanting to appear on this matter?
Yes, Your Honor, thank you. Dawn Sauer on behalf of the state.
Thank you. You have a status conference hearing on September 3rd at 8:30 and a preliminary hearing on September 5th at 8:30. Ms. Sauer, my understanding is that you wanted to, I did review your recommendations, but I understand that you wanted to make a record this morning.
Yes, Your Honor, thank you. The state is requesting a $250,000 cash-only bond based on the danger that the defendant and her accomplice poses to the community. Here they trafficked an underage 15-year-old for a period of 10 days, working together to do so. Oh, and I'm sorry, if posted, electronic monitoring, no contact with the co-defendant, who is the defendant's son, I believe, and no contact with any minors whatsoever is the state's request.
I did have a question, just based on the information that I reviewed. I did have some concern about advertising through electronic means based on the Form 4 statement. I'm not sure if you wanted to make a recommendation regarding that as well or no.
I did check it on my written recommendation of no internet, and the state does request that, Your Honor.
So I am going to order a cash-only bond in the amount of $150,000. If you are able to post bond, you'll be released to pretrial services on electronic monitoring. You cannot have any contact with the alleged victim. You can't have any contact with the alleged co-defendant. You cannot have any contact with any minors. You are prohibited from accessing the internet through any electronic means, and you cannot possess any weapons. If you fail to comply with your release conditions, or if you fail to appear for your court date, any bond that you post would be lost. A warrant would issue for your arrest, and additional bond would be imposed. This takes care of everything that I needed to advise you of this morning. If you have no questions for me, The officer is going to give you your actually, I had to reprint out her orders. The officer will give you your paperwork.
I do. As far as like the bond wise, I know I won't be able, my parents probably won't be able to make that amount of, so is there another option, how you say electronic monitoring?
Based on, I will just tell you, I will let you know where I came down on this. It is the fact that there is an actual victim.
Right.
This is not, and the alleged physical victim is 15 years old, and what happened to her. So if this is happening to her and it's a trafficking, then I am concerned about other young girls being trafficked. So my concern is not really at this time about you. My concern is really about the community, especially children, being safe with you in the community. That's what I
completely understand that.
And that's why I believe. And then there's also the additional fact that if you are convicted of this offense, there is mandatory prison time. So I have a concern about flight risk as well. Any other questions? Did I sign this?
So I just have to come up with some money?
So I've appointed an attorney to represent you. Your attorney can ask for a bond modification at the next court date, but that's what my order is for today.
Okay.
Mr. Williams? Sir, can you please state your first and last name and your date of birth?
Samaji Williams, 03/11/07.
You are here today on a new case. You were charged with one count of child sex trafficking, a Class 2 felony, one count of child sex trafficking, providing the means to do so, Class 2 felony, one count of child trafficking with the intention to traffic, a Class 2 felony, and one count of child sex trafficking by transporting the child, a Class 2 felony. The date of these alleged offenses is August 10th of 2025. I did appoint an attorney to represent you. Ms. Sauer, do you want to state your appearance at this time?
Yes, Your Honor. Dawn Sauer on behalf of the state.
You do have a status conference hearing on September 3rd at 8:30, a preliminary hearing on September 5th at 8:30. You have a cash-only bond. Oh, I'm so sorry, Ms. Sauer. You want to be heard on release conditions? I did review your recommendations, but do you want to make a record at this time?
Yes, Your Honor. Similar to the co-defendant, the state is requesting a $250,000 cash-only bond, along with the other conditions, if posted, electronic monitoring, no contact with the victim, no internet, no contact with any minors, no returning to the scene, which I believe was a motel where these events took place. And the state believes the defendant is a danger to the community, trafficking a 15-year-old girl for a period of 10 days. Thank you.
I am going to order a cash-only bond in the amount of $150,000. If you are able to postpone, you will be released to pretrial services on electronic monitoring. You cannot return to the scene of the alleged crime. You cannot initiate any contact with the alleged victim. You cannot have any contact with any minors, and you cannot access the internet through any electronic means. You are prohibited from possessing any weapons. If you fail to comply with your release conditions or you fail to appear for your court date, a warrant would issue for your arrest and a bond would, additional bond would be imposed. This completes everything that I needed to advise you of. If you have no questions for me. Yes?
I'm sorry to interrupt. I forgot to mention no contact with the co-defendant, please, who I believe is the defendant's mother. Can we add that to the conditions?
We have to modify the order. Okay, and also the additional release condition that no contact with the alleged co-defendant. Failure to comply with these release conditions or failing to appear for your court dates would result in the loss of any bond that you post. A warrant would issue for your arrest, and additional bond would be imposed. We're going to have your order ready for you in just a second. It looks like, do you have a question?
Wait, so this is, okay, so what am I doing after this? I go back to where I went, basically. I mean, where I was, right? To the cell I was at, or like?
This is where you initially come in. They're going to transport you to another location. And then your attorney will meet with you on or before September 3rd. Any other questions?
And then, yeah, no, that's it.
That's it? Okay. So
this isn't the time where I'm trying to, like, make myself, like, not guilty or guilty, right?
That is what you do through your attorney.
Yeah.
Ruben Ruiz, date of birth January 20th, 2000, is here on a new case. He was charged with one count of aggravated assault with a deadly weapon or dangerous instrument, a Class 2 felony, one count of theft or control of property, a Class 1 misdemeanor. I did find probable cause as to these offenses, and I did appoint an attorney to represent him. He has a status conference hearing on September 3rd at 8:30 and a preliminary hearing on September 5th at 8:30. He has a secured appearance bond in the amount of $50,000. Mr. Ruiz is not present in court today due to refusing to follow court orders. He will be advised that if he's able to post bond, he cannot return to the scene of the alleged crime, he cannot have any contact with the alleged victim, and he cannot possess any weapons. He will further be advised that if he fails to comply with release conditions or fails to appear for his court dates, that any bond that he posts will be lost, a warrant would issue for his arrest, and additional bond could be imposed. I will meet with Mr. Ruiz. If any changes are needed, I will make those changes either on the record or in writing. Amanda Boomer, date of birth October 3rd, 1995, is not physically present in court due to concerns of self-harm. She is here on a new case. She was charged with one count of burglary in the 3rd degree, a Class 4 felony. I did find probable cause as to that offense, and I did appoint an attorney to represent her. She has a status conference hearing on September 3rd at 8:30 and a preliminary hearing on September 5th at 8:30. She has a secured appearance bond in the amount of $1,000. If she is able to post bond, she cannot return to the scene of the alleged crime, and she cannot initiate any contact with the alleged victim, and she cannot possess any weapons. She will be advised that if she fails to comply with release conditions or fails to appear for her court dates, a warrant would issue for her arrest. She will lose the bond that she posted, and another warrant would issue for her arrest, and additional bond could be imposed. I will meet with Ms. Boomer. If any changes are needed, I will do so either on the record or in writing. Austin Duncan, date of birth September 29th, 1995, is here on one new case and on a probation violation warrant. Mr. Duncan is not present in court due to combative behavior. On the new case, he was charged with one count of possession of a dangerous drug, a Class 4 felony, one count of possession of drug paraphernalia, a Class 6 felony. I did find probable causes to both counts. I did appoint an attorney to represent him. He has a status conference hearing on September 3rd at 8:30, a preliminary hearing on September 5th at 8:30, and he has a secured appearance bond in the amount of $500. As to his warrant, his probation violation warrant, I appointed an attorney to represent him in that matter. He has a probation revocation possible disposition hearing on September 3rd at 8:30. He has a secured appearance bond in the amount of $250. Mr. Duncan will be advised that if he is able to post bond, he cannot return to the scene of the alleged crime, he cannot possess any weapons, and he must contact his probation officer within 72 hours of his release. He will further be advised that if he fails to comply with release conditions or he fails to appear for his court dates, that would result in warrants issuing for his arrest, and additional bond would be imposed. I will meet with Mr. Duncan. If any changes are needed, I will do so either on the record or in writing. This concludes our 8 a.m. initial appearance calendar. We stand in recess until 11 a.m.
All right, guys. All right.
Thank you. Please be seated. Oh, good. Thanks.
No. Normally you're just like in the corner, you're just like, but all right, cool.
What do you, it's just low.
5 seconds. Right here.
All right, this is the 11 a.m. initial appearance calendar for August 27th, 2025. Pardon me, the court's orders for the taking of fingerprints and DNA samples made on the 2 a.m. calendar on the first of the month will also apply to these hearings. We're going to start with Mr. Nathaniel. If you'll please come to the podium here in front of me, you'll be first. Nathaniel. After that, Alyssa, right here at the podium, sir. Alyssa Sandoval, will you go to the chair there? You're going to be next. Hello, sir. May I have your full name and your date of birth, please?
Nathaniel James Estiga, 6/11/1998.
All right, thank you. You're on one new case and a warrant in an older case. I'm going to start with the new case. You were arrested for, and the court finds probable cause for the following allegations. Aggravated assault on a law enforcement officer, that's a class 4 felony. Aggravated assault on a person bound, restrained, or otherwise unable to resist, that is a class 6 felony. Also resisting arrest as a class 6 felony. I am appointing a lawyer for you in this case. It will be the same person that you had for your other open case, which is number 31 on the calendar. In that case, you've already been charged with possessing dangerous drugs, a class 4 felony. Pardon me. You missed a sentencing hearing. Your sentencing on or about August 26th, and a warrant was issued for your arrest in that case. All right, you're going to have different court dates right now in the two cases because they're at very different stages of the proceedings. So beginning with the new case, you're going to have a court date on September 3rd, which is this Wednesday, September 3rd, 8:30 in the morning. That's a status conference with a preliminary hearing 2 days later, Friday, September 3rd at 8:30 in the morning. Your preliminary hearing, September 5th at 8:30. That is the new case. Also in the new case, I'm setting a third hearing. It's called a bail eligibility hearing. That's going to be the afternoon of September 3rd at 1:30 p.m. The purpose of that bail hearing is to determine whether you might be eligible for bail, because today you are not. You've come in with probable cause for new felonies while you have any pending felony case. I cannot give you bail today in the new case. I have to hold you for a bail hearing. The bail hearing will be in 1 week. That is the evidentiary hearing that will be on your paperwork.
Understood.
All right. Now, in the older case, whoops. Hey, can you fix the older case, 31? It says status conference and prelim. Okay. Thank you. No problem. We're going to send you for a status conference in front of the trial court, in front of the sentencing court. Is this still going to be EDC 5? Oh, good, okay. So I can get you a status conference in the older case as well on September 3rd at 8:30 in the morning. So that makes all of your court dates next week. We do need to reprint the one for the older case, and I'm affirming the bond set by the sentencing judge, and that was $2,000 cash only. That's the older case. That does not change your no bond hold in the new case. So you shouldn't try to post that other bond until you find out what's going to happen at your bail hearing next week. Everything's going to be on your paperwork. We're just getting that reprinted, and the officer will have that for you in a second. Thank you, officer.
Okay.
All right. All right, so if you step to your left, he's going to give you a
I'll bring it over.
All right, Ms. Sandoval? And then Terrell Caskey, if you'll come to the chair there, you'll be next. Right here, Ms. Sandoval. Hello, ma'am. May I have your full name and your date of birth, please?
Oh, this is Selena Sandoval, 11/8/2000.
All right, thanks. You're here on a new case and 2 probation holds. Pardon me. In the new case, you were booked in for 6 total counts of 3 are shoplifting as class 4 felonies, 3 are organized retail theft of merchandise as class 4 felonies. There is probable cause for all of those, and I am appointing a lawyer for you. I'm also appointing a lawyer in both of your probation cases. You are on probation in 2 separate cases for class 6 felony shoplifting, and the probation department will be filing petitions to revoke your probation in both cases. So you'll have a lawyer to help you, and you're going to have the same next court date for all 3 matters. It is this coming Wednesday, September 3rd at 8:30 in the morning. In the new case, it's a status conference. In the probation cases, it's a revocation arraignment hearing. Then you will also have a preliminary hearing in the new case only on Friday, September 5th, also 8:30 in the morning. In each of your 2 probation cases, the court finds you are substantially likely to be revoked to prison. So you do not have you do not have bond today in your probation cases. You are held no bond in both of those. In the new case, your bond is $10,000. It is secured with written conditions. You shouldn't try to post that bond if you are still being held without bond in your probation cases. It wouldn't get you out. So you will have the same lawyer for everything, and you're scheduled to be in court next Wednesday. If you please step to your left, I'll give you a copy of that paperwork. Thank you. All right, Ms. Caskey. And then after that, I'm ready to go on Mr. Olea. Are you defense counsel or are you sheriff's office?
Defense counsel.
Oh, okay.
Oh, yeah.
Oh, okay. Oh, that's right. I forgot it was going to be virtual. Okay, sorry. Didn't mean to accuse you of looking like a lawyer, but you kind of do. All righty. Ms. Caskey, if you'll come into the podium right here. Terrell Caskey. After that, Mr. Olea, will you go sit in the chair? You'll be next. Hi, ma'am. Can I have your full name and your date of birth, please?
Renee Caskey, 9/20/92.
All right, thank you. You are here on a new case. You were arrested for, you were arrested for 4 total counts of possession of narcotic drugs for sale. Based on what the police provided regarding field tests or other identification of the drugs, the court finds probable cause today for 2 of those allegations of possession of narcotic drugs for sale. The other 2 are not dismissed. I'm just not finding probable cause, but, sorry, someone's responding to internal stimulus back there, and maybe, might be okay. All righty. In any event, ma'am, the other 2 allegations are not dismissed. The state can still go forward on those. I'm just not setting release conditions for them today because they didn't provide enough information regarding drug identification. Finally, for possession of dangerous drugs for sale, that's a class 2 felony, and there is probable cause for that, as well as transportation of another person for the purpose of prostitution, and that's a class 5 felony. I am appointing a lawyer for you in this case. Your next court date will be September 3rd. It's a status conference in the downtown Superior Court with a preliminary hearing September 5th at 8:30 in the same court. Based on what's been alleged against you, I don't have an AG in this hearing, do I? Is there any AG here?
No.
Okay. I'm setting bond in the amount of $25,000 secured. I note the AG filed a written recommendation asking for $75,000 cash. talking about things that appear to apply to a different defendant and or are alleging things that don't seem to have, honestly, it actually looks like a different case. And if it's not, then this is very inadequately provided. So in any event, I'm not giving any weight to what the AG has recommended in this case, because I think without them here to explain it, their recommendation is nonsensical. So it's $25,000 secured with written conditions, and I note that the court found probable cause only for the items alleged to be in your purse. Other quantities of drugs, larger quantities of drugs, were alleged to have been found in a hotel room, or I think it was a hotel room, but they did not provide a sufficient connection between you and that hotel room for the court to find probable cause on those quantities. Doesn't mean you couldn't ultimately be charged with them, but so in any event, on this booking as currently presented, this is your bail. And I did appoint a lawyer for you. If you bond out, do not miss your court hearings. There will be a warrant issued for your arrest. And I note that you had a very serious arrest a few months ago that didn't get filed at the time. I'm not sure how familiar you are with our legal system. Those charges are not gone forever. The state has 7 years on the statute of limitations. They could well be investigating those allegations. So I tell you that in an effort to promote your compliance with release conditions. That I always tell people, it is unwise to make yourself interesting to the state, because then if there are optional things they could be investigating or looking into, you might give them a motive to do that. You need to come to court and comply with release conditions. If you don't, you could lose that bond money, and there will be a warrant issued for your arrest. Everything is on your paperwork. If you step to your left, the officer's going to give you a copy.
Thank you.
Thank you. All right, Mr. Olea, and then Selena Pearson, when you go to the chair, you'll be next. All right, see if I can get my video working, although if I have counsel with video, I prefer if you turn it on. Counsel?
I'm just audio, Your Honor. I apologize.
Are you on a phone, or you just...
I'm on a phone, yes, Judge.
All right, okay.
I do apologize, Your Honor. I only found out about this hearing at around 10:15, so this is the best that I could do.
Sure, I understand, but if you're in the Teams app, you probably have video. If you're saying you're not in a position to, it would be inadvisable to turn it on.
Yeah, I'm just on a phone. I'm sorry.
Okay, all right. All right. Mr. Olea, can I have your full name and your date of birth, please?
Anthony Michael Olea, 7/22/87.
All right, and then the appearance of the state, please?
Dawn Sauer on behalf of the state.
Okay, thank you. And the defense?
Morning, Your Honor. Jonathan Goebel for Anthony Michael Olea, who is present in custody. I will waive any reading, Your Honor.
All right, well, that's more of an arraignment thing. I am obligated to tell him why he's been arrested. Mr. Olea, you are here on a warrantless probation arrest, which would be for an allegation of violating no victim contact orders no victim contact terms of your probation. And before I go further, did the defense want to be heard, Mr. Goebel, on probable cause for that allegation?
No, Your Honor.
All right. And Mr. Olea, based on what the probation department has provided, the court does find probable cause to believe you violated the no victim contact term of your probation, which for specificity is term 10. Also, I find that you violated term 9 at least once, which was failing to allow the search of your person or property by APD. And there's an access one for being specific. Number 5, term 5. I would provide current address, reside there, and give them safe, unrestricted access to my place of residence. So I find probable cause for violation of all of those. Okay, so you do qualify for court-appointed counsel, but Mr. Goebel, I didn't look closely enough on your NOA. We're going to represent him for the whole case?
Yes, Your Honor. I was his counsel of record for the underlying case as well.
Okay, well, and that sort of resets in a PV scenario, so I just want to make sure. So I'm not appointing a lawyer for you, Mr. Olay, because you have hired one. Your next court date is going to be a revocation arraignment and possible disposition hearing September 3rd at 8:30 in the morning. That's this Wednesday in the downtown probation court, and that address will be on your paperwork. And before the court sets conditions of bail or release, what does the state want to recommend?
Yes, Your Honor. The state is seeking a $100,000 cash-only bond. In the underlying case here, the defendant was just sentenced 2 months ago for aggravated assault, domestic violence, where he ran the victim over with a motor vehicle, causing significant injuries, including breaking her leg. He was just sentenced 2 months ago, ordered no victim contact, and is already violating by hiding the victim inside his house. Also in the underlying case, while it was still pending and while the defendant was on felony release in that case, he was picked up for theft and was with the victim, violating his release conditions earlier this year as well. It appears he has no intention to abide by the court's orders, no intention to stay away from the victim, and the state is further concerned about his statements that if I go back, you won't take me alive, and believes that he is a danger to the community as well as the victim. For those reasons, the state's seeking the $100,000 cash-only bond.
All right, thank you. Mr. Goebel.
And Your Honor, thank you for taking the time. Obviously, I did represent him in the underlying case, and quite a lot went into this. And I wish that Mr. Schneider was appearing for counsel for the state, because he does know a lot that went into this and the decision for these probation terms. My client's SMI, Your Honor. In terms of his violations, I just want to address the theft that the state recommended. That charge was dismissed, Your Honor, by the city of Mesa. I know. I represented him in that case. They dismissed it. These probation terms here were very, very extensive for my client. He is SMI. He had a long history of substance abuse as well as mental health terms, Your Honor. And I wish I was there to show you copies of the plea agreement, all of these extensive terms, but they included mental health terms, domestic violence treatment. He sees a private psychiatrist for the mental health terms. He's getting drug and alcohol testing. Part of it is he has to take all of his medications as prescribed. He's in no way had any violations of those, Your Honor. In terms of these violations with victim contact, and again, going back to the underlying case, Your Honor, this victim always wanted to have contact with my client. In fact, she filed motions and requested specifically with Mr. Schneider, which was denied during the pendency of the case. To break it down, Your Honor, I mean, they've been together for many, many years. This unfortunate incident happened. I believe the plea agreement was reached because of the mental health and substance abuse issues that occurred, which was the cause of this unfortunate incident, but they are being addressed by Anthony, by the treatment that he is seeing. Quite frankly, Your Honor, the victim doesn't have any place to go, and she continues to have contact with my client. I'm not blaming the victim at all for this, Your Honor. Anthony does know that he's not supposed to have contact, but it's difficult for a real person when they're in a situation, in a real couple, Your Honor, when they've seen each other every day for 12 years and they count on one another, to just simply to not have contact. Given that he is not in any way a danger, she wants to have contact with him, Your Honor. And I know that Anthony does his very best, and he's trying hard, and I know because I'm in contact constantly, Your Honor, with his family. His children, their children in common, are being cared for by his parents. And I would say at least twice, 3 times a month since his sentencing, Your Honor, I've had contact with his mom, and I'm checking in, and Anthony's been doing very, very well. What I'm worried about, Your Honor, is that you place a large bond on him and he has to stay in custody. It's going to derail all of the treatment that has been working very, very well for him, which the whole goal of this agreement and for him to be on probation that Mr. Schneider and I worked out and that the judge accepted was that for him to be able to get this treatment. We would ask that you do allow him to be released, again, back to his probation supervision pending this probation violation, Your Honor. And then I understand that the victim was arrested on an outstanding warrant. If there could be more warnings to her to not have contact with him. But locking him up and stopping all of the treatment because of this contact, which there is no danger at all. I get what counsel for the state would read that one sentence in the Form 4, but again, my client is SMI, Your Honor, and when he's put in situations like this, he says some off-the-wall things. I've known him for many years. I represented him many years ago. I don't believe that it's in our community's interest or his best interest long-term for his rehabilitation if he's held in custody over this. So we would ask that he be released back to the probation without having to post a bond, Your Honor.
Your Honor, may I add a couple more things?
Sure.
Thank you. I just wanted to say that I have consulted with Mr. Schneider, who is the assigned DCA on this case, and sent him the Form 4 that has been provided to the court today, and he was in agreement on the $100,000 cash-only bond, knowing the facts of the underlying case. Additionally, at sentencing, the defendant was sentenced to 3-year supervised probation. That was on June 30th, but he was also sentenced to 90 days of deferred jail, which is set to begin in December. I also would add that it doesn't appear that treatment is working very well if the defendant is consistently violating release conditions and doesn't seem to have the ability to stay away from the victim.
All right, thank you. Mr. Olea, I've considered what's been alleged against you, the recommendation of the state and of your lawyer today. It is the court's decision today to set bail in your case at $100,000 secured with electronic monitoring if you do post it. The reasons include, and I will say the court also, I read all of the stipulations in your plea agreement as your lawyer brought it up. The first one is to have absolutely no contact with the alleged victim. I also read the offense description in the pre-sentence report as well. This court is not prepared to say under Rule 7.2c that you will in all reasonable probability be revoked to prison. I am not prepared to say that, so I'm not holding you without bond. But reading the offense conduct description in the pre-sentence report and the plea agreement in this case, the court notes that what was alleged against you was of extreme seriousness and is the type of behavior that could very, very easily have resulted in the victim's death. And this court speculates that the likely reason you got any probation offer at all is all of the reasons that your lawyer described regarding your mental health status, etc. This court does not believe that it ameliorates your behavior, the fact that, as was already obvious from reading the materials in this case, that the alleged victim is attempting and voluntarily initiating contact with you. You are in no way legally permitted to allow it or to respond to it. And the court believes that there's nothing in the record to indicate that your mental health challenges in any way impair your ability to understand that. You cannot. This court will not engage in side orders to a victim in a case not to have contact with you. This court lacks the authority to do that. She is not before me. She cannot violate your probation. Only you can violate your probation. And it appears that you dodged prison by a hair in this case, based on what you are convicted of having done. It was alleged there were independent witnesses in the case, and the court was frankly very surprised that somebody convicted of that offense conduct did not go to DOC. So the fact that so quickly and apparently, allegedly, repeatedly, these no victim contact orders have been violated, this court takes with extreme seriousness. And it is not up to the alleged victim whether she has contact with you. The court can prohibit you from doing it. She will never suffer a single consequence for initiating contact with you, but you can. And this court believes that her safety, essentially in this moment, takes precedence over all of any progress you've allegedly made in treatment. But I agree with the state. that the totality of what's being alleged against you strongly indicates that while you may have been showing up for treatment, which your lawyer indicates you have, it doesn't appear to have been having any significant effect. You're categorically prohibited from having contact with her. You do not reach out to her from the jail. You do not receive her phone calls. You do not respond. If she initiates it, you are not legally entitled to respond. So, that being said, this court believes that victim safety issues very much support the setting of a bail. And at this moment in time, the court is not prepared to say that cash bail is warranted based on the totality of the circumstances in the case. But those are the reasons for my order. I've also embodied the no victim contact order in my order, because although the court believes there is no possible excuse that you could offer if you have done this to justify what you have done. And the court believes that the victim initiating contact might explain it. It does not remotely excuse it, particularly in a case when you're not accused, you are convicted of having intentionally run her over with your car, more than what could be termed an accident. And so on these facts, in the absence of the totality of this, the court would hold you no bond. But the court is not prepared to speculate that you are that likely to get revoked to prison. I think you're highly likely to do your deferred jail time at a minimum. But in any event, I've spoken enough about this, but Mr. Olea, I cannot overemphasize how important it is to the court that we preserve victim safety, even when the victims are potentially doing unwise things, and that to in any way excuse your decision to violate court orders in a serious case by blaming the victim, it doesn't move the needle for this court at all. So everything's going to be in your orders, Mr. Olea. Remember, the no contact order applies 24 hours a day, 7 days a week, whether you are in jail or out of jail. No indirect contact, no social media, zero. All right, anything else from the state?
Your Honor, thank you.
All right, from the defense?
If Your Honor, if you wouldn't mind having your staff email me copies of his release orders, that would be great.
Yes. Well, yeah, we always do. Yes, she's got it. Okay, all right, yes, we will. All right, then we'll be in recess on your matter. You guys are welcome to disconnect. Obviously, Ms. Sauer, if you have other cases, you can stay in. Okay, thank you. All right, so you can go ahead and step to your left. We need to print that up. We're going to send it out to you. All right, then we're going to move on to Ms. Pearson, Selena Pearson. Where's Selena Pearson? She's dressed out. She might be asleep. She's got long, dark hair, and she's in orange. Selena Pearson.
Selena Pearson?
Oh, she's right there. Okay. Leonard Hawk, if you go to the chair right there, you'll be next. Right here, Ms. Pearson. All right. Good morning, ma'am. Can I have your full name and your date of birth, please?
Selena Rose Pearson, September 27, 85.
Okay, thanks. You're here on a probation violation case. You're on probation for a Class 3 felony, and there was a petition to revoke your probation filed back on December 20th of 2023. That petition alleges that you violated terms 3, 4, 5, and 15 of your probation. You'll get a copy of it from your lawyer, and I am appointing a lawyer to represent you. Your next court date will be this Wednesday, September 3rd at 8:30 in the morning in the downtown probation court. That will be a revocation, arraignment, and possible disposition hearing. And the court address will be on your paperwork. Your bond is $5,000. It is secured. If you bond out, comply with all of your written conditions and call your PO within 72 hours. The main number is on your paperwork. If you step to your left, they've got a copy of that for you.
Thank you.
Thank you. Mr. Hawk? And then Brian Mayer, we go to the chair. Hello, sir. Can I have your full name and date of birth, please?
Leonard Hawk, 10/10/85.
All right, thank you. You're here on a new case. You got arrested for one allegation of aggravated DUI as a Class 4 felony and theft of a means of transportation, a Class 3 felony. For purposes of this hearing, the court found probable cause on the aggravated DUI, but not for the theft of means of transportation because the police did not provide enough support on the knowledge element. So talk to your lawyer about that. The state can still go forward on the theft of means, But right now, I am not setting release conditions on it. I'm only setting release conditions based on the aggravated DUI allegations. So talk to your lawyer about how that works. If you hire one, wait a minute. This says you're not indigent. All right, this says you're working full-time for the construction company.
It was part-time. It's like a on and off job, construction.
All right, I'm gonna appoint a lawyer.
Thank you.
For you, Mr. Hawk. Give me 1 second. Okay, I am gonna appoint a lawyer for you. Your next court date is a status conference, September 3rd at 8:30 in the morning. That's this Wednesday, with a preliminary hearing September 5th at 8:30 in the same court. Bond in this case is set at $5,000. That is with alcohol monitoring if you post it. If you post the bond, you're going to alcohol test for us to prove that you are not drinking. You are absolutely prohibited from driving at any time. You do not have the current legal right, and there's probable cause to believe that you do it under very dangerous circumstances. You also have a history of alcohol-related arrests going back at least to 2012. So the court is very concerned that you are an alcoholic, and you will do this again if you are driving. So, no driving at any time for any reason, no weapons, no drugs without a valid prescription, obviously no alcohol. No contact with whoever owns the allegedly stolen car. If you step to your left, you get a copy of that paperwork. Thank you. Oh, I'm sorry, we need to reprint it if that one doesn't say lawyer. Yeah, because I did give him a lawyer. Yeah, thank you. Then Brian Mayer, we go to the chair. I'm sorry, to the podium, Mr. Mayer, and then Christian Mesa to the chair. Right here, Mr. Mayer. Hello, sir. Can I have your full name and your date of birth, please?
Brian Mayer, 8/13/91.
Okay, thanks. You're here on 3 bench warrants for failing to appear at a hearing that was set for 3 separate cases. It was a disposition hearing in one of the cases and a sentencing hearing in 2 of the cases. The 2 that you were going to be sentenced in are number 7 and 8 on the calendar, and in those cases, you were charged in both cases with possession of a narcotic drug, a Class 4 felony. And number 8 on the calendar, you were also charged with possessing drug paraphernalia, which is a Class 6 felony. Those are the ones where the hearing you missed was your sentencing. That same hearing was to be your disposition hearing on a probation violation as well. That's number 6 on the calendar. You're on probation for a Class 6 felony. So I'm going to give you a status conference in front of your sentencing judge. That's going to be this Wednesday, September 3rd, 8:30 in the morning in the downtown Superior Court. They will give you a new sentencing date on Wednesday, but right now I just set the status conference for Wednesday. I'm going to affirm the bond set by the sentencing judge, which is $1,000 cash only per case for $3,000 total. If you bond out, comply with all your written conditions, call your PO within 72 hours, don't miss your court date. If you step to your left, they have your paperwork for you. Mr. Mesa, Christian Mesa, and then Gerald Lejos. We go to the chair. Right here, Mr. Mesa. Hello, sir. Can I have your full name and your date of birth, please?
Christian Ray Mason, 4/11/1996.
All right, thanks. You're on a probation warrant. You're on probation for a Class 4 felony. There was a petition to revoke your probation filed on July 3rd of 2024, so July of last year. That petition alleges that you violated terms 3, 5, and 15 of your probation. You'll get a copy of it from your lawyer. I am appointing a lawyer for you. Your next court date is this Wednesday, September 3rd at 8:30 in the morning in the downtown probation court. That will be a revocation arraignment and possible disposition hearing. I'm affirming the bond that was set by the judge who issued the warrant. That is $1,250 secured. If you bond out, comply with all of your written conditions, call your PO within 72 hours, and don't miss your court dates. If you step to your left, I have your paperwork for you. Thank you. Mr. Lejos, Gerald Lejos. Pardon me, and then Colleen Medina. Pardon me. Sir, can I have your full name and your date of birth?
Gerald Lejos, 1/14/97.
Okay, thank you. Mr. Lejos, you are here on 2 things. One's a new case, one is a warrant in a pending case. I'm going to start with your new case. You were arrested on a total of 5 things. For purposes of this hearing only, the court found probable cause on 3 of those, not the other 2. The 3 that I did find probable cause for are resisting arrest passively and false reporting to law enforcement. Those are Class 1 misdemeanors. Also, obstruction of justice by the refusal to provide a true name. That's a Class 2 misdemeanor. I did not, for purposes of this hearing only, find probable cause on the alleged narcotic drugs and drug paraphernalia because the police didn't provide enough information to support the allegation that they were narcotics. So for purposes of this hearing only, I'm not finding probable cause or setting release conditions for those. You are still accused of those crimes, and the state can still go forward on those, but I am not setting release conditions for those. Your next court date, I am going to appoint a lawyer for you, and your next court date is going to be Wednesday, September 3rd. That's going to be a status conference for both cases. You can talk to your lawyer more about how this works next week at your status conference. And your preliminary hearing for both cases is going to be September 5th at 8:30 in the morning. Now, in the older case, I do need to tell you what you've been charged with. Those charges that were already pending, this is from last May, are narcotic drug possession, a Class 4 felony, drug paraphernalia possession, a Class 6 felony, and false reporting to law enforcement, a Class 1 misdemeanor. So you'll have the same lawyer for both, same court dates for both. Those are next week. And I'm setting the same bond in each case. It is $1,000 secured with written conditions that I'll let you read for yourself. And I note that if I had found probable cause for the new felonies, you would be held without bail in those cases. The only reason I'm giving you any bond is that I didn't find probable cause for any new felonies, but I believe bond is very much warranted in this case when you are accused of dodging arrest, when you're out on release and you're in a warrant status for a case in which you're accused of lying about your identity to the police. So the court believes you don't have any intention of voluntarily appearing for court. That's the reason for the bond. It's $2,000 secured. If you post it and you miss a court date, you will lose that money and there will be warrants issued for your arrest. Everything's on your paperwork and you'll be back in court on Wednesday. If you take your paperwork, it's just there to the left on the corner. Thank you. Ms. Medina, Colleen Medina.
Yeah, everything's on paperwork.
And then Darius Charlie, we go to the chair. Hello, ma'am, can I have your full name and your date of birth, please?
Calling Regina, 10/24/1994.
10/24?
Yes.
Okay, thanks. You're on 3 things. 2 are probation warrants. One's a warrant from the Peoria City Court. I'm going to start with your 2 probation cases. You're on probation in 2 different felony cases, and there were petitions to revoke your probation filed back on June 25th of this year. Those petitions allege that you again violated your probation by violating terms 3, 5, and 15. You'll get copies of those petitions from your lawyer, and I am appointing a lawyer for you in probation court. Your court date there is this Wednesday, September 3rd at 8:30 in the morning. It's a revocation arraignment and possible disposition hearing. The address for the court is on your paperwork. And I'm affirming the bond set by the probation judge for both of those. It is $1,000 secured per case for $2,000 total. In the Peoria City Court, they issued a failure to appear warrant for you on April 17th of this year. That is in a case in which you've been accused of theft by shoplifting, a Class 1 misdemeanor, and obstruction by the refusal to provide a true name. That's a Class 2 misdemeanor. And your next court date in the Peoria City Court is Tuesday, September 2nd, 9 in the morning. That's an arraignment hearing. I am affirming Peoria's bond, which is $250 secured. So your total bond across all 3 cases is $2,250. Everything's on your paperwork. If you step to your left, you get a copy of that. Thank you. Mr. Charlie, Darius Charlie, and then Elizabeth Vargas. Will you please go to the chair? Hello, sir. Can I have your full name and your date of birth, please?
Darius Charlie, 04/30/2005.
All right, thank you. You are here on a warrant for failing to appear at a status conference in a case in which you've been charged with aggravated assault as a Class 5 felony. This warrant was issued April 23rd of 2025. You already have a lawyer in this case. Your next court date will be September 3rd, which is this Wednesday at 8:30 in the morning. That is a status conference in the trial court. The address in downtown Phoenix will be on your paperwork. I'm affirming the bond set by the trial judge, which is $1,000 secured. If you post it, comply with all of your written conditions and don't miss your court date. They've got your paperwork there for you on your left. Thank you. Ms. Vargas? And then Miguel Jacobo, we go to the chair. Where's Elizabeth Vargas, please? Elizabeth, she's dressed out. She's about 40 years old. She's got, there we go. Okay, here she comes.
Arms out of your sleeves.
Right here, ma'am. Good morning, ma'am. May I have your full name and your date of birth, please?
Elizabeth Vargas,
Which date of birth?
4583.
Okay, thank you. You are here on 2 probation warrants and 1 warrant from the Peoria City Court. In your 2 probation cases, you're on felony probation, and there were petitions to revoke your probation filed
I
on
don't
May
have
29th.
felony probation.
Well, it appears that you do. And I've had you in front of me before, ma'am, and I literally remember you telling me last time you weren't on probation. You are on probation. I'm going to give you a lawyer. Your lawyer will help you understand that. But the petitions allege that you violated terms 3 and 5. Your lawyer will give you copies. You're going to go to court next Wednesday, September 3rd, 8:30 in the morning in the downtown Superior Court. And I'm just affirming the bond set by the probation judge in each of those cases. It's $1,000 secured per case for $2,000 total. Now, Peoria City Court also issued a warrant for you for failing to comply with their court orders in a case in which you've been convicted of disobeying a court order. That's a Class 1 misdemeanor. This warrant was issued August 5th of this year. So you go to Peoria City Court, pardon me, on Tuesday, September 2nd at 9 in the morning, and I'm affirming their bond as well. It's $500 secured. So your total bond is $2,500 secured. If you bond out, comply with your conditions, don't miss your court date. If you don't bond out, you will be back in court for both or for all 3 of your cases next week. You'll have a lawyer in every case. You step to left to give you your paperwork.
So am I be released?
You have to post $2,500 if you're going to be released. If you don't post it, you'll stay in custody and they'll take you over for court next week. Good luck, man. All right, Mr. Jacobo, Miguel Jacobo.
Come on up.
After that, Casey Manuel, will you please go to the chair? Casey? Hi, sir, can I have your full name and your date of birth, please?
Jacobo, 1790.
Sir, you're going to have to take your face out of your...
Jacobo, 1990.
Okay, thank you. You're here on a probation violation warrant. You are on probation for a felony, and back on June 13th, there was a 3rd petition to revoke your probation filed. It alleges that you violated terms 3 and 4. You'll get a copy of it from your lawyer, and I am appointing a lawyer for you. Your court date is this Wednesday, September 3rd, 8:30 in the morning in the downtown probation court. That's a revocation, arraignment, and possible disposition hearing. I'm affirming the bond that the probation judge gave you. It is $250 secured. If you bond out, you have to comply with all of your written conditions and call your PO within 72 hours. If you step to your left, Mr. Jacobo, they will give you a copy of your paperwork. Step to your left, sir, take your paperwork. Right there. Good luck. All right, then Ms. Manuel, we come to the podium. After that, Mariah Whitehead, you can go to the chair. Hello, ma'am. Can I have your full name and your date of birth, please?
Kathy Manuel,
What's your date of birth?
7/16/92.
Thank you. You're here on a new case. You were arrested for possessing narcotic drugs, a Class 4 felony, and criminal trespassing, a Class 3 misdemeanor. There is probable cause for those, and I am appointing a lawyer for you. Your next court date is a status conference, September 11th, which is about 2 weeks from now, 8:30 in the morning. Preliminary hearing, September 15th at 8:30. And in this case, although you do have a prior felony conviction, it's quite old, and so I'm going to follow the recommendation to just release you on your own recognizance. That means on this type of charge, we're willing to let you prove whether you will or won't come to court. If you don't come to court, you're going to get a warrant, and you're going to end up back here with a bond.
Okay.
So if you don't like jail, you need to come to court.
Okay.
It's September 11th and September 15th. It's all on your paperwork, okay? Don't go back to where you were arrested. They do allege that you were trespassing at the time you were arrested, so don't go back there.
Okay.
Everything's on your paperwork. If you step to your left, you should be released within, I think they say, around 6 hours. Try to be patient. If you step to your left, you get that paperwork.
Thank you.
Good luck.
Okay.
Ms. Whitehead, and then Jermaine McCorvey, we go to the chair. Hello, ma'am. Can I have your full name and your date of birth, please?
Mariah Janae Whitehead.
What's your date of birth?
83191.
Okay, thanks. You're in a new case. You were arrested for possessing dangerous drugs, a Class 4 felony, and drug paraphernalia, a Class 6 felony. There is probable cause for those. You were also booked in for possession of narcotic drugs, but for purposes of this hearing only, I did not find probable cause on the narcotics because the police didn't provide enough information to support their allegation that it was narcotics. It's not dismissed, though. I'm just not setting release conditions for it. So you need to talk to your lawyer about how that works, but the state can still go forward against you on that charge. I'm just disregarding it for purposes of setting release conditions. So talk to your lawyer about that. I am appointing a lawyer for you. Your next court date is a status conference in 2 weeks. It is September 11th at 8:30 in the morning with a preliminary hearing September 15th at 8:30. The address in downtown Phoenix is on your paperwork. You also qualify for release on your own recognizance. That means get yourself to court. If you miss a court date, you're going to get a warrant and you're going to get a bond. So just like I told the last defendant, if you don't like jail, you need to come to court. If you step to your left, you get a copy of your paperwork. And Mr. McCorvey, after that, Francisco Flores. We go to the chair. Hello, sir. Can I have your full name and your date of birth, please?
Jermaine McCorvey, 8485.
8485?
Yes, ma'am.
Okay, thanks. Sir, you're here on 3 matters. I'm just going to take them one at a time. One's a new arrest, 2 are probation hold. Starting with the new arrest, you were booked in for possessing dangerous drugs, a Class 4 felony, and resisting arrest, a Class 6 felony. Give me 1 second, though. Hold on. Okay, I apologize. No, I misunderstood something in your paperwork. I need you to sit down. I actually have to redo your paperwork. I missed something when I was preparing. So if you go ahead and have a seat, I need to fix your paperwork, and I'll call you back in a few minutes. Hold on. Okay, those are good to reprint. All right, Mr. McCorvey, you can go ahead and come back in. Okay, right there, sir. All right, that was just a simpler fix than I thought. Okay, sir, I already got your name and date of birth. You're here on 3 things. All right, in the new case, you were booked in for 2 things. I found probable cause for one of them, but not the other, and that is resisting arrest, a Class 6 felony. There is probable cause for that. There's not, for purposes of this hearing only, probable cause for the alleged dangerous drugs because the police didn't provide enough information to support the allegation that what you had was methamphetamine. The dangerous drug allegation is not dismissed. I'm just not setting release conditions for it. I'm disregarding it for purposes of this hearing. So talk to your lawyer about how that works, but the state can still go forward on that charge against you if they want. You are going to have a lawyer appointed for this case and for both of your probation cases. You're on probation in 2 felony cases, and the probation department will be filing petitions to revoke your probation in both cases based on this new arrest. So you have a lawyer for everything. You're going to have the same next court date for all 3 cases. It is September 3rd, which is this Wednesday, 8:30 in the morning in the downtown probation court. That's a status conference. Your preliminary hearing will be September 5th at 8:30 in the new case only, same court. In the probation cases, that is a revocation arraignment and possible disposition hearing on Wednesday the 3rd. So you'll go Wednesday and then again on Friday just for the new case. All right, in each of your 3 cases, you have a $1,000 secured appearance bond for $3,000 total. If you bond out, comply with all of your conditions and call your PO within 72 hours. If you step to your left, let's make sure we have the new paperwork, gentlemen. You got the fresh paperwork? Okay, thanks. All right, then, don't come in yet, but do I have both Francisco Flores and Araina Wellner in court, both of them?
Yes.
Are you Mr. Flores? Oh, no, you're just nodding your head. Okay, because what I'm trying to figure out, let me just let's start with Mr. Flores. Will you just stand up? I want to just find out, just stick your head in. Sir, sometimes on cases like this where both parties get arrested, it's domestic violence, I'm planning to release both of you. I can do a better job making orders if I do the cases at the same time, but neither of you has to do it that way. If you don't feel like being in the same space as her, you don't have to. I'm going to ask her the same question. But if you say, no, I don't want to do that, I'm not even going to ask her. We're not going to do it that way. I'll do them one at a time. Are you okay doing it together at the same time? No. Okay, all right, then I'm not even going to ask her because both parties have to agree. So you can go ahead and come in, and then I'll do Ms. Wellner's case after. All right, so let me have your full name and your date of birth.
Francisco David Flores, 9/17/03.
Okay, thank you. You're here on a new case. You were arrested for disorderly conduct. It's a class 1 misdemeanor. There is probable cause for it, and I am appointing a lawyer for you. Your your case is going to go out of the Hasayampa Justice Court, which I thought was in Wickenburg. It seems strange. Hold on a second. That's up in Surprise. Hang on a second, because there was something else funny about this. Okay, I see. Right. All right. Because the other one's going to El Mirage. All right, so your case is going to go at the Hasayampa Justice Court. The address and Surprise is on your paperwork. Okay. And your arraignment hearing is going to be September 10th at 9 in the morning. So that is about 2 weeks from now. Okay. As I noted, I am planning to release you on your own recognizance. What police describe is basically a mutual combat scenario, and I am not showing any prior arrests for you, so I'm planning to release you. But what I need to do is make orders that make sense as far as where people are going to go, who's going to stay, who's going to go, and I may have to, because you're not in here together, I may have to send you in and out before I decide. So, but sometimes people tend to agree on the basic facts, like which one of you would it be easier to move. And so I'm going to order no contact while the case is pending, which means one of you needs to go somewhere else. And you indicated to pretrial you do have a friend that you can stay with. Is that correct?
Yeah.
Because you would get a civil standby. You could go collect belongings. Okay, all right. And so, all right, I think that's what I'll do. It seems pretty clear unless you wanted to be heard on that. Do you want to say anything about that?
Do you know, like, how long?
Well, it's until another court orders otherwise. And for reasons that we don't see it that often, and I think they meant to do it. The police are allowed to do this. But the El Mirage PD booked you into a justice court, and they booked your co-defendant / co-victim. They booked her into the El Mirage City Court, which is rather annoying because that puts 2 courts into the mix, and it's going to complicate things. But as far as this court's, authority or even the advisability of just undoing that, we don't. So it's going to be until your court changes that order or lifts that order. So you guys may both be on a lease there or a deed, which is a property issue. That's not a
criminal.
It's not a criminal one, no. And so that's why in cases like this where neither of you has any criminal history and neither of you is accused of doing anything that, even if I believed it was absolutely true, I'm not really worried that you're dangerous to this person. Even if it's 100% true, I'm not terribly worried about you guys. If you go do dumb things, I can't help that while the case is pending. But on these facts, I'm not holding anybody in jail. I just want to put in orders that will keep the peace while this plays out. That's the important thing. So all I can tell you is your orders are going to come out of that justice court. That's the court that you have to deal with about what they will let you do, what they won't let you do. She'll be dealing with the El Mirage case, and you're the victim in the El Mirage court. She's the victim in the Hacienda Justice Court.
Okay, I get it.
And so, like I said, this makes it unnecessarily and a bit foolishly complicated. And who knows, maybe the El Mirage city attorney, that's probably who's going to have to prosecute these. I don't know. Maybe they'll get them into the same court. I don't know. And I don't want to minimize that. The elements of disorderly conduct are met, meaning the elements of this crime are met to a degree of probable cause. But this is the type of case that, frankly, I don't picture the system getting very excited about. So what's going to happen from here, I don't know. But you don't want to take a very inconvenient situation and turn it into more things like getting arrested for the misdemeanor of violating a no victim contact order. If a no victim contact order is violated in a way that constitutes harassment, you could be booked in for felony harassment. Right. So this could go from a regrettable situation, but not anything that really pegs the meter on ongoing dangerousness, to a rap sheet. So don't do dumb things while this case is pending. I mean, neither of you's even been arrested before. So don't start getting arrested for violating these orders because the underlying allegation is on the less serious end of the continuum of domestic violence. I don't want you to get any idea that you should mess with release conditions. Right. But how long it lasts, in your case, it's up to the Hacienda Justice Court. So, but you'll have a lawyer. The public defender does represent in domestic violence cases in justice court. Unfortunately for her, the El Mirage City Court does not currently have that policy that I'll talk to her about. But you're going to have a public defender when you get there. They can give you more information about this. So in the meantime, what I'm going to do is give you a civil standby at the, is it an apartment?
Yeah.
To collect your belongings. And so you have to call El Mirage PD, just call the non-emergency number and say, I need a civil standby, please. They'll send an officer to go with you and keep the peace while you collect some basic stuff, medicine, ID, car keys, some clothes. You know, they're not going to stand by while you move out, but I am told the nicer you are, the longer they will give you. Okay. So no weapons, no drugs without a valid prescription. Obey any order of protection that might be served on you. I don't know that either of you are going to do that. And by the way, it just makes everything more complicated for everyone, but you're entitled to go get an order of protection if you wanted to, and so is she. So if you get served with one, you have to comply with that as well as a term of release. Don't respond to any contact from her. Just go get your stuff with the cops, go stay somewhere else, show up for your court hearing, okay? It's still going to take quite a few hours to be released. I'm sorry that it's so slow, but you should hopefully be out by dinner time. Okay. If you step to your left, get your paperwork. All right. Right, I did not. Correct. Okay, Ms. Wellner? Okay, this one I am going to have to edit. 36, yeah, sorry. Okay, hi, ma'am. Can I have your full name and your date of birth?
Elena Wellner, 08/30/03.
Okay, thanks. You're here on a new case, which, as if you were listening, has been booked into the El Mirage City Court. Mm-hmm. And it's also disorderly conduct, a class 1 misdemeanor. I do find probable cause for that allegation. So you need to go to court in El Mirage on September 2nd. So your court date, is coming up super fast.
Tuesday?
Yeah, the address is in El Mirage.
Okay.
And I am releasing you on your own recognizance for the same reasons I told your co-defendant / co-victim. Mm-hmm. And based on me ordering him to go somewhere else, I'm going to let you go to and reside at the apartment. Okay. Still, don't initiate any contact with him. Do not respond to any contact from him. No weapons, no drugs, no driving without a valid license. If you get served with an order of protection, you have to comply with that as well. And I just have to edit yours because we set them up so that I could go either direction without much trouble. Let's see. Okay, and just make clear you can't live at the same location, but I'm not, I'm going to take that out. I'm just going to say no contact, even if he contacts you first. And like in his order, I put the statute in there that makes it aggravated harassment if you do anything when there's a no victim contact order, anything that could be booked as harassment. That can be one text. If a court finds probable cause for harassment in violation of a criminal court order, that's a felony. So don't do that. Same thing I told him, don't take a lousy but temporary situation and turn it into a rap sheet by violating release order.
For sure.
So everything's on your paperwork. Now, I cannot appoint a lawyer for you today because the city courts, we do the initial appearances for all the smaller cities that don't have their own jails, most of them, and they have entered into new governmental agreements with us, and they're asking us not to appoint lawyers in domestic violence cases if we are releasing the person. They want to decide whether they do that or not. And so you can, under many circumstances, get a court-appointed lawyer in a domestic violence case, but the El Mirage judge is going to decide. And, often I think that they don't do it unless the state is asking for jail time. But that's a situation and an issue that I'm not taking up. All I'm letting you know is you might qualify for a court-appointed lawyer if they're willing to give you one. And on your income, you might not qualify anyway. So I'm not appointing one for you today. But you have the right to hire one this afternoon from the jail. You can hire a lawyer at your own expense, or you can go represent yourself at the next hearing, and you would just end up speaking directly to the prosecutor.
So is it for my income? Is it because I make too much?
Right. Okay. And it's going to be up to, chances are, El Mirage, if you wanted to try to qualify there, they're going to have you fill out a bunch more paperwork and do some things on their end. That's entirely up to them, and they may not want to do it anyway. And they have just asked that we don't do it here. We leave it to them, as long as we're not holding the person, and I'm not holding you. So everything's on your paperwork. It's going to take a while to be released, just like I told your co-defendant / co-victim. Just comply with these conditions. Don't miss your court dates. Don't pick up any new charges. All right. If you step to your left, get your paper. Thank you.
Will the paper have the time on the court date?
Everything, yes. Everything you need to know. Yes. All right, Mr. McHale, will you come in?
You have that laminated paper? Yes. Yes, sir.
Right here, sir. Hello, sir. Can I have your full name and your date of birth?
Okay, I'm Tom Stacy, born June 18th, 1970.
Okay, and then it looks like we do have the prosecutor appearing, so ma'am, go ahead and state your appearance for me.
Thank you, Your Honor. Dawn Sauer for the state.
All right, thank you. Mr. McHale, Mr. Stacy. It's McHale Stacy? Okay, sorry. You probably get that a lot.
I do.
All righty. So, Mr. Stacy, you are here on two matters. One is a new case going out of Maricopa County, and the other one is a probation warrant from California. So I will deal with the probation warrant in a few minutes because that involves extradition rights, which is different and a little more complicated than an in-state case. But I will let you know before I keep going on your new charges that in the California probation case, regardless of whether you want to fight extradition or not, I'm obligated by Arizona law to hold you without bail. You are not getting bail today in your California case, no matter what happens in the Arizona case, because it is a probation warrant. So, in any event, I'll give you more detail on that. I think it's probably important for you to understand that, is that even in the complete absence of the new Arizona case, I would be legally obligated to hold you without bail because California wants to extradite you. So,
They want to come for probation?
Correct. There's a probation warrant out for you from the state of California.
But it's over like 2 years old, correct?
Yeah, they confirmed it within the last 24 hours. That
And
means they confirmed they want to come and get you.
They want to come get me?
Correct. But I'll give you more information on that. I'm going to deal with your new case first, because that's what the prosecutor is here to be heard on. So I want to give her a chance to do that. So in your new case, Mr. Stacy, you were arrested for one allegation of kidnapping, which the court finds probable cause for as a Class 2 felony, aggravated assault with a deadly weapon or dangerous instrument, that's a Class 3 felony, and threatening and intimidating, which is a Class 1 misdemeanor. Based on what the police provided, there is probable cause for all of those things. I am appointing a lawyer for you. Your next court date in this new Maricopa County case is going to be this Wednesday, September 3rd, 8:30 in the morning. That's a status conference in the downtown Superior Court. Your preliminary hearing will be Friday, September 5th at 8:30 in the same court. All that's going to be on your paperwork. Before I set conditions of bail or release, I'm going to hear the state's recommendation. Go ahead, ma'am.
Thank you, Your Honor. The defendant is a repeat violent offender. He is on probation in California. He's also a flight risk. He has felony convictions in California for spousal abuse and terrorist threats. And then now here in Arizona, he kidnapped the victim from her father's house at knife point. He held her the entire day. He held her overnight until the next day. That's a very long period of time to hold someone against their will. He threatened her life. He threatened her with a hammer and a knife. And the state is concerned that he is a flight risk due to leaving California, and also concerned he's a continuing danger to the victim. The state is seeking a $100,000 cash-only bond, and if posted, then no returning to the scene, which was the victim's father's house, the initial scene. No alcohol, no contact with the victim, and electronic monitoring.
All right, thank you. Mr. McHale, Mr. Stacy, I've considered what's been alleged against you, your criminal history, and the recommendation of the state, and the court agrees that the victim safety issues posed in this case,
I just want my things.
as well as the possibility of flight risk, flight to avoid prosecution.
I don't have the money to get on plane.
Those are strong factors in this case.
I don't have any, history out here at all, man. I haven't been in trouble out here. I've been doing quite good out here since I've been out here.
All right. Well, the allegations are extremely serious, and the court is very concerned that you're extremely dangerous to this victim, that you could hurt or kill her.
I don't have
and that you're not going to voluntarily appear for court hearings.
Yes, I will.
Well, you've got a fugitive warrant from California that strongly suggests you won't. I
did not know I didn't have one.
Okay, well, you do. So,
I've been
bail is set in the Arizona case at $100,000 cash only with electronic monitoring if you post that bail. That doesn't change the no bond hold in your California case, though. But I'm going to order pretrial supervision with alcohol testing and monitoring because there is a documented history of alcohol abuse. Absolutely no contact with the alleged victim, not from inside the jail, not outside the jail, not through third parties, not through social media. Absolutely no contact with the alleged victim or her family members or her property. No weapons, no drugs, no alcohol. You get served with an order of protection. You have to comply with that as well. All right, and counsel, did you want to be heard on the fugitive matter, or did you want to just be excused from this hearing?
I do not need to be heard on that matter, Your Honor.
Okay, thanks. All righty, so Mr. Stacy, you're also here on a warrant from the state of California, and this comes out of, looks like Los Angeles County, and it's the, it issued, the warrant has been outstanding since June 2nd of 2023. It is a probation violation warrant. So, as I noted, I have to hold you without bond no matter what you decide. But if you wanted to waive extradition in this case and agree to go back to California, I could take a waiver for you today. That's completely optional, and this is not your only chance to waive extradition. It's just your first chance. Some people want to.
If I waive extradition and I go back on my own?
No, if you waive extradition, we hold you no bond until California has had 30 calendar days to come and get you. Those 30 days don't start until you're done with any local cases, and you very much have a local case.
Right now.
So if you waive extradition in the California case, You're going to be held no bond. As I said, I have to hold you no bond either way. But you'll be held no bond immediately in that case. That no bond status will persist throughout the entirety of the Arizona case. Once the Arizona case is done, that means dismissed, convicted, or acquitted. Once that case is done, then California will get 30 calendar days to come and get you. If they don't, you do get released, but the warrant stays active in the national system, and you could be rearrested on the identical warrant the next day. Now, if you don't want to waive extradition because you want to think about it, I cannot appoint a lawyer for you in the extradition case because extradition proceedings are civil proceedings. They're not criminal proceedings.
Like an attorney, ASAP.
Sorry?
I would want a court-appointed attorney.
I cannot appoint a lawyer for you in an extradition case. You don't want one?
No, I'm talking about on the other case.
Yeah, you do have one.
A court-appointed attorney? I don't want a public pretender at all because I don't know what they're talking about.
I'm sorry, I'm confused. I appointed the Maricopa County Public Defender to represent you in the new felony case, the new one. You do have a lawyer.
He's court-appointed? He's not?
Of course. I appointed him, therefore he is court-appointed.
When I'm going to be able to talk to this person? Can I talk to this person?
At or before the next hearing. So,
at or before?
Yes. So what I'm going to do is I'm going to give you a court hearing in your fugitive case. That's going to be September 8th. 1:30 in the afternoon. And as I said, I do have to hold you without bail. We're going to give you a copy of your rights in the California case because extradition rights are different, but they are. You have the right to have an extradition hearing within 90 days. You have the right to hire a lawyer at your own expense, and you have the right to insist that a governor's warrant be issued by the governors of both states before you can be taken back to California. So you have all of those rights.
I'll be in custody until then?
At a minimum, correct. At a minimum. That's September 8th at 1:30. That's going to be on your paperwork. We're just getting that printed up with a copy of your rights. We're going to send that out for you. All right.
Because somebody said I did something, you guys are going to automatically say that I'm doing that, so I'll be held against my... For what?
No, the two things do operate differently. In the new case, the police provided allegations of evidence that they have that supports the allegation that you did those things.
How so?
So, you can talk to your lawyer and go over that with your lawyer, sir.
Where did you see the knife and the hammer and all that stuff?
Also, the California case operates entirely separately.
I'm not talking
the California case is what is holding you without bond, even regardless of any other charges.
Okay.
You do not get bond in the California case. They've got your paperwork for you. Just step to your left. All right. So, are we able to move traffic now, or should I do my house calls if we need a second?
Yeah, we're gonna move it right now.
Okay, all right. Okay, so you can go ahead and come in. We're gonna wait for the... Did he just throw it on the floor? Okay. Well, it'd be kind of hard to remember your court dates if you throw it on the floor. Right here, sir. Just give me 1 second, okay? They're just having just a few issues there. I'm just waiting for the door to close, counsel. Okay. All right, sir, may I have your full name and your date of birth, please?
James Edward Fitch, April 16, 2004.
All right, and the appearance of counsel, please?
Ron Sauer on behalf of the state.
All right, thank you. Mr. Fitch, you are here because you've been booked in on 17 counts of sexual conduct with a minor. Those are class 2 felonies, and this is a legal definition, dangerous crimes against children. And the court does find probable cause on those based on what has been alleged by the police against you. The alleged offense dates range from 2024 to 2025. I am appointing a lawyer to represent you in this case. Your next court date will be a status conference September 3rd at 8:30 in the morning in the downtown Superior Court with a preliminary hearing September 5th at 8:30 in the same court. Before I set conditions of bail or release, what does the state want to recommend?
Your Honor, statements made by the victim indicate that this started when she was only 10 years old and continued up until the present day at 13. It appears this went on for about 3 years. The state is also concerned the defendant may be a flight risk. The Form 4 indicates he's from Germany. It looks like he was staying with the family, and this started around when he was 18. The state, it's unclear to the state what his immigration status is, whether he has a passport, and whether he might be inclined to flee to Germany if released. These are very serious allegations, and he's facing significant prison time for these offenses.
All right, thank you. Mr. Fitch, on the question of your connections to Germany, do you hold any passports?
Not on me currently. I do have an American passport. I was born over in Germany when my dad was stationed over there. I was born on an American base.
Okay.
I stayed there until my parents came back to the States. They got divorced around that time, and then I went back and forth between my dad and my mom in between Arizona and Washington State. But I have no other connections to Germany.
Okay. All right, so your representation is you don't hold the German passport, you're not a German national.
I have no dual citizenship. I have no citizenship of Germany at all.
Okay. All right, so Mr. Fitch, I've considered what has been alleged against you. The weight of evidence that has been alleged, if they have the evidence they say they have, it appears to be a very strong weight of evidence. I've considered the potential punishment in light of how it may affect a person's likelihood of appearing for trial or surrendering for a potential guilty verdict. And in this case, this court remains very concerned about flight risk. The court was already concerned and already contemplating a bond in the amount that the state just recommended, even before I saw their recommendation. If there were some more evidence, and if you have any more, tell me, counsel, but I didn't see any other allegations of connections to Germany other than it listed as his birthplace. And I would set bond considerably higher if there were some more specific indications of connections to Germany. So I don't know if you have any, counsel?
There was nothing other than the reference to Germany and just the unknown I had at this point in time.
Okay, understood. All right, then I'm not considering that other than, I guess, in the acknowledging that I saw that. But of course, there are thousands of children born every year on military bases around the world who are American citizens. So, okay. But I was already concerned. I'm extremely concerned about the risk of victim or witness intimidation or retaliation because this remains a very young person, a young child. And the allegation is extensive sexual abuse over a very long period of time and starting at age 10. And Arizona has a law that says sexual conduct with a minor, 12 or under, carries a potential life sentence. And so the court believes that anyone facing a potential life sentence and what appears to be a strong weight of the evidence has a motive to flee, whether they are innocent or not, to avoid a potential life sentence. And the court is very concerned that you pose a risk to children in the community because sex with 10-year-olds is unequivocally aberrant. It is not biologically normal. It generally comes from urges that the research shows that is not generally a crime of opportunity. That is a crime of pathology, which tends to indicate people may commit it more while cases are pending. So the court is very concerned about all of those things. So for all of those reasons, the court is going to set bail in your case in the amount of $250,000 cash only. And you are required by law, if you post that, to be on an electronic ankle monitor because you are accused of sexual crimes against children. Also, the nature of these offenses and the extensive nature of them leaves the court still very concerned about flight risk and risk to children in the community. So you will be on house arrest even if you post a bail unless and until another court orders otherwise. My order is for house arrest. Absolutely no contact with the alleged victim or her family members or property, whether you are in or out of jail. You can do a civil standby at that location to collect belongings because the police say that you had been residing there. So if you're out of custody, you'd have to arrange with your surveillance team and the police to go over and do a civil standby to collect belongings, but you cannot go there on your own. Absolutely no contact with anyone under the age of 18. It's my understanding from your interview you do not have any children of your own. Is that correct?
Yes.
All right, so absolutely no contact with anyone under the age of 18 for any reason. No weapons, no drugs, no alcohol. Everything else is going to be on your paperwork. Counsel, anything else today on this case?
No, Your Honor, thank you.
Okay, thank you. And so, Mr. Fitch, I did appoint a lawyer for you. You'll be back in court next week. You can speak with your lawyer then, and we're going to get that printed up. I got to sign it. Okay, we're going to get it printed up and sent out for you. So if you go have a seat, we're going to send out your paperwork. All right, thank you. And counsel, thank you. You're welcome to disconnect. Have a great day.
Thank you, you too.
I should face this way. Bye. Okay. All right. So I have 3 house calls, Mr. Boyd, Mr. Denoyer, and Mr. Valenzuela. Officers, are they not physically present in court because they've been isolated by the sheriff's office as a potential risk to themselves or others? All right, I do have an affirmative answer from the sheriff's office. I'm going to conduct those 3 initial appearances in-house immediately after this recording. I will advise Damari Boyd, born 119 of 03. He's here on a new case. He got arrested for criminal damage, a class 6 felony, preventing the use of a telephone during an emergency. That's a class 2 misdemeanor. There is probable cause for those. I am appointing a lawyer for him. His next court date will be a status conference, September 3rd at 8:30, and a preliminary hearing is set for September 5 at 8:30, both in the downtown Superior Court. And based on the reasons set forth in my written order, I am inclined to set bond in his case in the amount of $500 secured. He appears to be an extremely poor candidate for pretrial supervision, and so I'm not going to even try it unless he convinces me otherwise when I conduct the initial appearance. So I'm presuming, I'm going on the assumption that my inclination will be $500 secured. With orders not to return to the scene of the alleged crime, he can do a civil standby to collect belongings, but then he has to find a new place to stay. No weapons, no drugs, no alcohol. He has to obey any order of protection served on him. Gary Denoyer, born 12/12/85, is here on 2 probation warrants. He's on felony probation in 2 different cases. There were petitions to revoke his probation filed in both cases back on July 17th, alleging that he violated term 3. I'll let him know I'm appointing a lawyer for him in both cases. He'll get copies of the petition in both cases from his lawyer at the next hearing, September 3rd, 8:30 in the morning, in the downtown probation court for a revocation, arraignment, and possible disposition hearing. And I am planning to set bail in each of his cases at $250 secured for $500 total, with written conditions I will go over with him. Jesus Pinera Valenzuela, born 11/29/96, is here on a new case. He got booked in for dangerous drug possession, class 4 felony, drug paraphernalia, possession class 6 felony, and criminal trespass class 3 misdemeanor. There is probable cause for those. I am appointing a lawyer for him. I'm currently inclined to release him to pretrial services. It looks like he's on a non-acute suicide watch, so I will go and talk to him, provided it appears that he will come to court and comply with release conditions. It is my inclination to release him to pretrial services. With a status conference September 11 at 8:30 and a preliminary hearing September 15 at 8:30. Along with written release conditions I'll go over with him, which do include no going to the scene of the alleged crimes. If anything changes, after I conduct these initial appearances, my final orders will reflect the court's ultimate decision. The court will not be updating this recording. My final release orders in each case will reflect the court's decision in the case. All right, we're going to stand in recess until 2 p.m. this afternoon.